Hi guys, it's Kathy. I hope you're doing well. So we have a lurker who just can't join in chat, but they know you all because they see you all the time. They watch and they see you all, but they don't know you all. I mean they know you all, but you don't know them because they're lurkers. And they're equally as part of this family as we all are. They know Linus's birthday. They know everything. So they live in Australia, and CJ actually knows them. So we have to wish them a happy birthday. We just have to. We have to go in comments after this video. We have to wish them a happy birthday. Um, so they know they're part of the family too, which they are. Now, Carolyn, I don't often say this in my life, but my mouth can't do what you want me to do. I tried, I practiced. Her name is Zara. I can't do it, CJ. Her name is Zara, which is not the way it's pronounced in Australia. Ka, ka. I had instructions on how to say her name, but it's Zara. I can't. Zara. See what happens when I try to say it right, CJ? It just sounds like I'm having an episode. Happy birthday, Zara. Happy birthday, and thank you so much for watching. Appreciate it. We all appreciate it. So, we're going to continue with the Stalker trial. And this pro se guy who really is doing, I mean, it's a train wreck. He's pro se. It's a train wreck. But, like, the bathrooms are clean in this train wreck because he actually does pretty well, you know. Oh, thank you. Thank you, Kelly. Thank you, Casey. I have to tell you something, Casey. Every time I see your name, the song Carrie plays in my head. But I don't just hear the song Harry. I see Europe. I see the big yellow hair. I see the gorgeous face. I I love that group. He is so cute. I don't remember his name, but so every time I see your name, I see this gorgeous guy burst into my head. So thank you. Hi, Dale. I used to date a Dale a long time ago. Yep, that was when I was a teenager, young and stupid. Look, if you read this, just pretend that I pronounced it right. Just pretend KC pronounced it right, which she probably did. Yeah, it's probably just me. Security definitely pronounced it right. And so did Rebecca. All right, and we're going to get busy. We're going to get going with this trial, this train wreck. Day 2.
Remain seated, come to order.
All right.
Judge, Commissioner speak.
Pardon?
I'm trying to pull up some information. I was wondering if I will be able to use it. It's information that's in the system of a protection order that was put on her by other individuals.
Mr. Nicholson, if it's stuff that's public record, you're going to have to get that on your own. And I'm not going to keep delaying the trial because I've got.
I'm asking, can I use it?
That's up to you. You try to use whatever you want. It's up to the state to object. I can't tell you one way or the other until I know what it is. And the state's had an opportunity. Well, before I see it, the state's had an opportunity to look at it. So I don't know if you want to go ahead and show Miss Jones. Were you shown what it is he's talking about?
They do for me
too. What it
too.
is, Mr. Nicholson?
I need to print it out.
Okay. All right. Well, I'm going to go ahead and have the jury back. Let the record reflect, though the court's not required to, given that Mr. Nicholson announced earlier yesterday that he left his discovery disclosures that the state gave him at home in Florida, I'm assuming. Court has provided him what he filed attached to his motion in the record, some matters. But Mr. Nicholson, I'm not doing that again. Those are about 30 pages of documents.
About discovery? No, it's not.
No, I'm talking about what you have filed in the record in this case as attachments. So in any
Can I have one too, please? Maybe.
case, we're ready for the jurors to come back out. All right.
Hi, Timmy. How are you feeling?
Jurors entering.
All right. Please be seated. Welcome back, members of the jurors. Anyone not complied with the court's instructions regarding communications of any type about this case? Anyone overheard any communications? All right, has anyone posted, email, tweeted, text, all right, about the case? All right, hearing no response, we can go ahead and bring Ms. Wahlberg back to the stand. Thank you. All right, Mr. Nicholson, you may continue with your cross-examination, sir.
All right, ma'am. So you said,
I didn't get one.
You know, you on several occasions, he hitting on you?
Yes.
So.
That's my bad, isn't it, guys? I forgot to tell you what the trial's about. Real quick. My cow. This man and this woman were dating. Were they married? I don't know. And now he's like sending her a bunch of messages. So he replies to people who comment on her feed, just like we did for Judge Fleischer. And if you didn't, darn it, why not? Why are there only 170 some comments? Most of them aren't from us. I would say we did maybe 70. Why not? Why didn't you comment anyway? He's like calling her, texting her. Then she got a protection order. And he's still contacting her. And calling her and texting her and going on social media and everything. So now she brought him in. Well, the prosecutor brought him in for stalking. So this case is about stalking. He is pro se. He is questioning her because she's a witness right now. And it's lovely.
A text message that was sent from.
Oh, hold on. Just let Ms. Jones look at it. Okay. Are you trying to tender that?
Yes.
You want to show it to the
To the
witness?
witness and
Okay,
make sure she's
all right.
verified.
Hand it to the deputy. Thank you.
Thank you. She's gonna love it. She's gonna love it. She's
Are
gonna
you
love
familiar
it.
with that document?
Thank you.
Yes.
All right, so in that document, you said that I was never beaten on you, and that document was dated when?
It doesn't have a date. Oh, no, it does. 10/26/21. And it say, I never said you was beating on me. It's not saying, and maybe we're talking about that moment, but maybe we're just talking, I don't even know. I don't even know what's the message before it. Can you show the message before it?
I'm going to object. It's been established that the date of the document you tendered, which I do not believe the state was provided a copy of,
It's in the-
was October 25th, 2021, which is outside the relevant time frame for this case.
All right. Well, Mr. Nicholson, do you care to respond? What are you
yes,
trying
because
to,
they just went back.
let me ask you,
I'm
what are you trying to show?
I'm trying to show that this person is a compulsive liar.
Okay, overall.
So with that document, you say I was beaten on you. You say how many times that you got, you know? Like, what was the beatings like? How
Throwing
did
me
he
in
beat
the
on you,
wall,
ma'am?
pulling my braids out, throwing me in the wall, pulling me in my braids out when I tried to run out the door and you grabbed me back and you pulled my braids out and you put your knee in my stomach.
When
Oh,
did this
yeah.
episode?
Okay. Yeah, we could go there.
When did this episode happen, ma'am?
When I came back to your house by myself after you took the tracker out of my car, but I came back, when I ran outside with the neighbors and I yelled help, you pulled my braids down by the couch and you pulled me by the futon and you put your knee in my stomach. And you
So-
said I should kill you because no one would know.
So with that
I
being
remember.
said, again,
That's what
how many times did a situation like that occur then, ma'am?
it occurred? A lot of times.
That situation, so you stayed with the person that put their knee in their back, put your hair out,
You did.
and ma'am, answer please, because this is hard. Like you're telling me you stayed with a person for 2.5 years,
I did.
and he was beating on you,
I did.
and you hit him back
I did.
because he was beating on you.
I did.
So when was the first time Mr. Nicholson beat on you?
When we went to the bar around the corner when your friend came in town and we had a drink.
I need a date, please.
I don't remember the date. It was years ago. It was years ago, but you
Yeah,
did
if
it.
someone beat on you, you should be able to remember a date. I need a date because you're sitting here.
Okay, Mr. Nicholson, hold on, ma'am. You can't argue with the witness, so you just have to ask a
Can I have a
question.
date, ma'am? I need you to come up with a date.
Hold on, Mr. Nicholson, if she says she doesn't know the date, then you need to just move on to your next question.
Okay.
I can
So,
get you a date.
I'm sorry, I didn't hear you.
I have a picture of the bruise in my phone with a
Sometimes.
date. If you need a date, I could go get it out my phone for you.
All right.
But I have a date in my phone with the bruise on my arm.
so you was attacked and abused on that date.
CRD, old school mod. Mod from way back when.
And you say many more dates. So you have more pictures or more bruises that you took?
I also have messages of you.
Ma'am, can you tell the person to ask the
Yes,
Hold on.
yes, yes.
Hold on a moment, ma'am. All right,
I have
hold
the
on,
proof.
ma'am. Hold on. Ms. Jones, you're saying improper.
Attempted impeachment, that's what he's trying to do, and it also appears he's trying to impeach her about matters, again, that are not relevant to this case. He is so far, I think, unsuccessfully failed to establish credibility.
All right, Mr. Nicholson, what is your reasoning for this line of questioning about?
the credibility that this person is telling a story that we never had an incident where I.
Hold on. You can't testify. You have to tell
Um,
me what it is that you're trying to show through
I'm
this
trying to
line of
show
questioning.
that this person is lying about being beat multiple times or being beat, period.
Okay, so Mr. Nicholson, she's already answered your question. If you think that you can show something otherwise, you may have to do it another way.
You objected
Okay.
to the letter showing that she said I never beat on her.
You haven't tendered it.
Ma'am?
You have not tendered it. You have not asked it to be admitted into evidence. So there's been no objection.
Can I admit that into evidence, ma'am?
All right, is that marked? Is that your first exhibit?
Yes, ma'am.
All right, so defendant's exhibit 1. Is there any objection, Ms. Jones?
My objection.
That has to be Miss Jones making all that noise with the microphone because none of these people are.
It's dated October 2021, and the purpose was to impeach your credibility again. It's been updated.
All right, I'm going to overrule the objection. I'll allow the defendant's exhibit 1 to be admitted. Any other questions, Mr. Nicholson?
Yes.
So now that it's been admitted, you need to, unless you're going to use it again, you need to give it to the clerk.
Oh.
Okay, thank you.
Tokyo, I can't compete with God.
Okay. All right, Madam Clerk, you can just hold on to it. If he needs it, he can ask for it. Thank you.
Continue.
Here to get it.
Is my turn?
Do you have any other questions?
Yeah, I'll continue.
Yes, sir.
All right. 7/26, you left my home. So the day that you claimed you left my home, who was with you when you left the home?
Am I here for the relationship or
Okay,
the-
you don't get to ask questions, excuse me, just to answer questions. I know it can be frustrating, but this is a process.
me and my children? Me and my 3 children were together when we left the home.
And at that time, you left at what time was it when you left?
It was like 6 or 7 in the morning.
Okay. That day, did Mr. Nicholson put his hands on you?
No, your child was there.
Judge, again, I'm going to object as to relevance because this is exactly what I previously was concerned about. He is trying to get into the entire scope of their relationship, the reasons for the breakup, and this is not how you impeach the witness.
All right.
If he wants to take a stand and testify,
This is crazy. They are doing this all in front of the jury. Normally, when something like this happens, they ask the jury to leave. They argue their points. They bring the jury back in. They're just doing this all right in front of the jury. So he's able to say a lot to the jury. It doesn't matter, but he's able to say a lot to the jury that normally he wouldn't be allowed to say. I don't know why Tammy is doing this, but maybe Tammy's doing this because neither of them asked specifically for a sidebar. No one asked for a sidebar, so she's letting it go on.
that what she is saying is wrong, then he absolutely has that right. But right now, this is way outside the scope of what we're reporting on.
right,
Judge, the
Mr.
relevance of this situation, she opened this up by going back and
See, he's not doing a bad job. He objected. I mean, she objected to him going through this line of questioning. The judge asked him why. He said credibility. That is a valid argument. He kept going and started testifying and got shut down. But he turned around and said, she opened this up by saying our past relationship. That is a valid lawyer-like point. He's not doing bad. It's a train wreck. It's a dumpster fire. But yeah, JoJo, normally in the courtrooms that I get, you can't have it all. You can either hear the judge or you can hear the prosecutor. You can't hear them both. At least we hear them.
to what she claimed that happened. I'm here trying to show the courts that this person is a compulsive liar. There's no evidence to any abuse ever
Right.
taking place physically by me to her.
All right,
Only
Mr.
from her to
Nicholson, I'm going to sustain the objection. You can choose to put forth evidence some other way, but continuing to ask her these questions that you then disagree with her responses, the state is correct. That is not the way that you can impeach this witness if that's what you're seeking to do.
Okay.
So I'm going to ask you to
Move
stick to
forward.
what's relevant to the charge.
So the chart to the chart.
Okay.
All right. On the,
And again, for anybody who missed it, that he is being charged with breaking a protection order. He is being charged with contacting a protected person. So that's the only thing relevant in this trial is, did he break this protection order or not?
the date of I was put on protection order December. So, ma'am, have you ever responded or contacted Mr. Nicholson from the date
She boring.
of the protection order all the way to the date of his incarceration?
I responded, yes,
You responded how many times?
as many times as I could have after I tried to ignore you enough. I ignored you.
So do you feel that you didn't want to be contacted? Why didn't you block the person from contacting you with his email? How
Are you withdrawing that
no,
first
yeah, let me
question?
draw that first question. Ma'am, how many different communications did Mr. Nicholson use to contact you?
2, email and TikTok. Remember?
Okay. So he contacted you through email. He never called you, he never texted you, only through email, correct?
And TikTok.
Only through email, correct?
No.
How did the defendant contact you through TikTok, ma'am?
You went to my comment section where people replied and you made videos. So they were on my page and I was able to see the videos because you went to my commenters and made reply videos to get to me when I ignored your email, sir.
So you telling me that Mr. Nicholson contacted you through TikTok directly to you?
You came directly to you searched my name, you went to my video, you went to my comment section, sir, you made a reply video. So the notification will come to my notifications.
Can you please present that to the court, ma'am? I need that presented.
They have them.
Can you please
I
present that?
don't know what they did with them.
Can you please present that to the court? Witness, did you bring your own evidence? I wonder what the exhibit would be called if the witness presented the evidence.
They have them.
Okay.
Mr. Nicholson, that is not the way you can.
Can the courts, I need to see that evidence.
Mr.
Videos?
Nicholson, that's not how this works. If you
Okay.
want to consult with Ms. Walker, you can do that. I'll give you a brief moment to do that, but that is not how this works. And I'm not in a position to advise you or the state on how to present your case.
Yes, ma'am.
I need
Alright,
to
so-
see that evidence.
You did respond to Ms. Nicholson multiple times, correct?
I did.
All the way from the beginning of the protection order to the end,
Yes.
right? I mean, to the, what's the name?
To June.
And you said again, why did you respond?
Because you would not stop. If I did not answer your text, your messages on email, I ignored you a lot of times. You would go to social media and then you will message my parents. You sent my stepdaddy a video of you in a car at 2 a.m. talking to him, trying to talk about me. You did that. You did.
The TikTok videos, my TikTok videos are public, which are yours, correct?
Yes.
So that means your TikTok videos automatically come to my page, right?
You don't follow me, Derek. You came to my page. You typed my name in and responded to my commenters to get to me. I would have never looked anything up of you. I did not want to see you, hear your voice. You done enough to me, enough for me to not, I don't even want to see you today. So yes, you did do that.
Yes,
You
ma'am.
did. You came to my page, comment, so that I could see what you had to say about me. Yes, you did that. Your mother back there told you to stop.
What was
You
the
did.
comment on the page, ma'am, that I made to you?
Judge, I sent her a Court Vibes video. It's all good. I wasn't contacting her. I just sent her a Court Vibes video. Innocent. Go about your day.
And what he's being accused of, and I think we're getting down this very lengthy rabbit hole of TikTok videos.
All right,
Um,
hold on.
Judge, this whole situation started about TikTok videos. This situation is not about harassing nor intimidation. I made a
All right,
video and I'm
Mr.
trying to.
Nicholson, you have to
Video.
respond to the objection. It sounds like you're making an overall argument about the case. So do you have a response to the particular objection?
Object to the videos. Yes, I object because the videos are relevant because it was my First Amendment right to make these videos, and they're using these videos to say that I did something purposely.
All right, I'm going to sustain the objection.
Because you
and
did.
The court also finds that the question has been asked and answered. So let's move on to your next line of questioning, if any, Mr. Nicholson.
So with these TikTok videos, you say, Mr. Nicholson, what's his name? All right. What emails did you
Fighter.
find to be
Fighter, let's go.
harassing and intimidating?
When they were coming 2 minutes apart from 12 to 12, 24 hours, nonstop, that's harassing me, sir. That's harassing.
So it's if you replied to the emails, did you reply to the emails?
I've answered that.
You replied to the emails.
Judge objection as to answer.
Sustained.
You say harassing and intimidate. Was the conversations that Mr. Nicholson was seeing about, was it about the child?
They were about the relationship, the DNA, the child, the past, the abuse, the rape. Yes, they were. I'm so tired.
Let's ask this person. Harassing, intimidation.
Hold on a moment. Do you need a moment?
I do. I'm so tired, man.
Okay.
I'm so tired.
He says,
No discussions about the case. Judge, your microphone's off.
could you?
So tired.
Giving her a break and kicking the jury out.
All right, you can step down. Thank you. All right, be seated. Thank you. Here you go. Let me get. You know, so Ms. Jones, Mr. Harrison, and then Mr. Nicholson.
Do you guys remember the treehouse shooting video that was in this same courtroom?
Ms. Walker gets a copy. During this brief break, the court is providing you with the first draft of the jury charges as well as the verdict form. Let me also find out from the state about how many witnesses do you have after Ms. Wahlberg?
I have two, Judge.
Two.
I
Okay.
have the detective and I have the responding officer.
Okay. Okay. All right. Do you know how long they will be? I'm trying to determine when to break for lunch.
For direct examination, they should not take very long at all, Judge.
Okay.
Maybe
All
a
right.
total of a half an hour max.
Okay. All right. We'll see how long it takes to get through cross-examination here, and then I'll regroup and check in with you. The jury, I think, got here, what, about 9 o'clock? Okay. All right.
Judge, if I might suggest, I think it might be appropriate after cross-examination, if the court wanted to take a lunch break at that point,
Okay.
when we come back, say if we come back 1:30, then I think the state, again, we could wrap that up pretty quickly with my
Okay.
other witnesses.
Mr. Nicholson?
Judge, I need like 15 minutes to go have something printed out, if it's possible.
I'm not going to give a whole 15 minutes. I don't know where you're going, but
I don't know how long it's gonna take me to get upstairs to print the thing out and then come back down.
Mr.
I mean,
Nicholson, what
the
is
doc-
it that you're trying to print? How many pages?
It's 2 papers, it's a document, 2 documents of a restraining order, a order that
He just clearly proved that she's a liar, didn't he? Isn't that what he was trying? Yep.
TPO order that was put against Ms. Wahlberg.
Even though he
Okay.
admitted everything.
Against Ms. Wahlberg? I
Yes.
thought you said Ms. Walker. Okay, Ms. Walker, if you have the document, you can go email Ms. Baker to print
I
it out.
do
I'm
have
not
it.
going to delay this much further.
Yes, Your Honor, I was gonna say too, if he needed to use my computer, I could print it on the lunch break and we could introduce it as an exhibit that way, but he could use a computer, but if you want me to, that would be faster to keep.
Is it in conjunction with the witness that's on the stand, Ms. Wahlberg?
Yeah.
No, we need to do that now. So if you can go and do that now, Ms. Walker.
Yes, Your Honor.
Oh.
I've just sent it. I've tagged the court. I've tagged the state. I asked for 2 copies so the state can have a copy at the table and Mr. Nicholson could present it as
Okay.
evidence.
I want
And
to just
I'll-
make sure she's checking her.
Okay. And would the court like me to go inquire with Ms. Baker?
Sure.
Yes, ma'am.
Yeah, because he admitted everything to her, to all of us.
All right, counsel and Mr. Nicholson, are we ready to proceed? I don't see Ms.
She was here, she just stepped out.
Oh, okay.
Judge, I'm gonna make a preliminary objection on the record.
Okay.
Note that the 2 documents I've been provided.
It's okay, Micah. I was not drinking when you said that.
2015 against Ms. Wahlberg, which is way outside anything even remotely.
I'm so sorry, Sue.
Does not involve Mr. Nicholson and Ms. Wahlberg. This is well in advance of their relationship by, I think, a good 4 years at least before when she testified they began dating. And it does not actually go to credibility, the fact that there was an
So in case you didn't hear what's going on or you were watching chat like me, she was in a prior relationship that was rocky. Police were involved against her. And he wants to put that into evidence, that saying that she's a violent person.
issue in a relationship with a different man.
Okay. Mr. Nicholson, what would be your purpose? And I guess, to the extent you're seeking or would be seeking to admit these
This
behavior
into
warrants.
evidence, yes, ma'am, as a credibility to the person, like based off the Brady, evidence. Because for personal credibility of the witness, I'm trying to bring up to show the credibility of the witness, and also it's in favor of the Brady evidence that I'm trying to bring this evidence in.
Okay. And I guess I don't know, these were warrants, good behavior warrants against Ms. Wahlberg, Ms.
Correct.
Jones?
And it does not go to the truth of the matter asserted in this case at all. Yeah, I think it's just simply an attempt to smear Ms. Walker, quite frankly.
Okay.
It's showing that this person is a violent person,
Yeah.
that she, it was not just me that she attacked other people, and I'm just showing the pattern of this person and what she's doing.
And Judge, propensity for violence is not an issue in this case, and that is contradictory to what you just said, that this is a question of credibility. It is an
Okay.
improper attempt to impeach her.
You don't know
All right,
her.
Mr. Nicholson, unless you can show me some law that is something that you can impeach her with as far as it relates to the issues of this case, which is whether you violated a temporary protective order. I don't know that I understand the relevance as far as her credibility that she's had a prior good behavior warrant
Because she-
back in 2015. Is that the most recent? Is 2015?
Yes, it would be 2015 that this happened, you know what I'm saying? And, I mean, I'm just showing that this person was, violent. She's saying that I was the violent one, and this person is the one that has
Well,
continuously have these records of violence.
Mr. Nicholson, if you want to put forth evidence that she's been violent with you, you can do that. I'm not going to start a mini trial about the basis for those good behavior warrants, which I can see that devolving into that. So I'm going
You know
to
what I'm saying?
sustain the
You know what I'm
objection.
saying?
If you want to have it marked so that it can be in the record for
Yeah.
purposes of any appeal, should you wish to do that, you can go ahead and pass it to the clerk to get it marked as Defendant's Exhibit 2 and show that it's not been admitted. It can be a composite. You can just hand it to the clerk, Mr. Nicholson. Thank you. All right. Is it marked? Both are marked? So it'll be
I paused it for a second because it looks like my internet is having a day. All right, here we go.
Oh, hold on. We can have Ms. Wahlberg come. Hold on. Oh. Hold on, Deputy Casper.
Yes.
Hold on a minute. Have Ms. Wahlberg come back. Hold on, I'm gonna have Ms. Wahlberg come back first. All right, thank you.
So Peg Leg understands this guy is facing prison because this is a criminal trial. He committed a crime. Yay, Casey, thank you, thank you, thank you.
All right, please be seated. Welcome back. Members of the jury, has anyone not complied with the court's instructions regarding communications about this case of any type? Has anyone overheard any communications about the case since leaving the courtroom? Okay. That being said, Mr. Nicholson, you can continue your cross-examination of Ms. Wahlberg.
Ms. Wahlberg, what made these messages sent to you harassing and intimidating? What made these?
Casey, did you see who got it? Bren got it. Yay, thank you, Casey.
Did
You answer that already?
He asked me that last time before I left.
I was picking up where I left off.
Ms. Wahlberg, you can go ahead and answer the question. If
Okay,
there's no objection.
What made him harassing?
Yeah, what made the messages that were showed to the court harassing and intimidating to you? What put you in fear of your life by those messages?
Objection, I think that's a misstatement of prior testimony and a compound question.
Okay, so Mr. Nicholson, ask her one question at a time. So your first question was what made them harassing or intimidating, correct?
Yes.
All right, so allow her to answer that question.
Questions harassing or intimidating.
What made him?
I mean, what put you in fear from the messages that were sent to you? What put you in fear of your life or a person's life? Harassing, intimidating, that's what that means, to be put in fear of your life or somebody else's life.
I got it.
Yes.
I don't think she's in actual fear. She's admitted a couple times she beats him right back when he raises his hand on her.
He is misstating the law and making a legal argument, as well as misstating prior testimony.
Well, Miss, I don't know that it's a misstatement of the law. To the extent he's intimating that she testified specifically to that, saying she was in fear of her life. I don't recall hearing that, but I will allow him to ask his question, but it needs to be some overruling your objection. But Mr. Nicholson, you need to ask one question, allow her to answer it. If you want to ask another question, withdraw the previous question and then proceed with your next question. So what is the question that
He
you're
won't do
posing to
that,
this
guys.
witness?
Judge, if I
Hold on.
could make an exception about the legal portion, I believe that the law on this states that she does not actually need to be in fear for her life.
Well, that part, you may be correct, but in any case, he isn't, and let me just remind the jury, the law will come from me, not the parties or the witnesses. So to the extent anyone has made or makes a comment about the law, you are to rely on the court's instructions only as it relates to the law. With that being said, Mr. Nicholson, what is your question?
From what I understand by the law, that for
You
harassment
understand nothing.
and harassment and intimidation is to put a person in fear.
Mr. Nicholson, just ask your
the
question.
question.
Yeah, just ask her the
What put
question.
you in fear of your life, man? What email? Which email particularly?
Judge, he asked the question.
I'm gonna
Oh,
answer.
okay.
I'm ready to answer. What put me in fear is when a person was served with a piece of paper to tell me not to be contacted, when he can't even follow the law, who knows what this person is capable of outside of following the piece of paper. So I feared you because the messengers were 2 minutes apart, 6 months straight, all day long.
And you were responding to the message, correct?
When I had time, because if I did not, you will go to the public platform once again and pick at me, message my parents, and put my personal information online. So yes, I did respond to stop that part of my life from being put out to the world. Yes, I did.
Have you ever went on social media and contacted anyone about Mr. Nicholson on your Facebook, talking about something that he did to you?
Judge, objection, the relevance of this.
All right, Mr. Nicholson, where are you going with this line of questioning? Tell me what the relevance is to,
The relevance to her is does she
not
She
to
talking about-
her,
I mean,
to the issue
to the
that's
issue?
being tried today.
to
Wake
show that
up,
this
Susu,
person-
wake up.
She's sitting here talking about the TikTok and the information, but she went on social media also
Okay,
trying to talk about me.
Judge, Ms. Walker had an TPO against her.
all right,
So this is.
I never did that though.
all right, sustained.
So you say because of
Who believes that she went on social media and talked about him? I don't. Here's what I think happened, and this is just what I think, not what I know. Although I should have went to her page and got some of this for you guys. I should have. Why didn't I? I don't know. I don't know. But here's what I think happened. I think that she made a post or a TikTok that said something like, "Beautiful day today. I think I'm going to get sushi." That in his brain, that was her trying to reach out to him because maybe, I don't know, he hates sushi. So he's thinking she's attacking him, or maybe they used to go get sushi together, so he thinks that she's reaching out to him because she wants to go back to that sushi place with him or whatever. I think she posted something and he just made it about him.
Mr. Nixon contacting you and you responding back to him, that's what put you in fear of your life.
That's not what I said.
You said that Ms. Nixon was contacting you and if Ms. Nixon did not respond to you, that he was going to continue contacting you, so that's why you responded to him.
No, if Mr. Nicholson has a piece of paper that the judge gave him and they told you not to contact me, and a person who thinks they're above the law who kept contacting me will do anything and think they can get away with it. So yes, I was in fear because you would not stop. 2 minutes apart, 12, 13, 14, 15 emails nonstop every single day for 6 months, sir. 6 months from the time you got the TV.
Okay, we need a different word because stalker is not what he is anymore. No, he's been sending her messages every single day, 2 minutes apart for 6 months. That's not a stalker. We need a bigger word. We need something that, Jay.
HBO to the day you were arrested. You wrote me a message.
Okay.
Okay.
And you, let's see. Said TPO, you said you was afraid. That was the reason you was afraid. You know what? Can't answer the F about this. See, all right, so through the emails that you sent, you stated in one of the emails that you had someone was going to my page talking about pages that I were making. Is that correct?
I don't remember.
You don't remember?
Judge, again,
What does that have to do with
relevance.
this?
All right, so I've sustained,
The relevance?
yes, I've already sustained that objection.
His right hand
before
hates him.
To that line of questioning, Mr. Nicholson.
Ma'am, I'm arrested on this witness.
All right. Any redirect from the state?
No, Judge.
All right. Is this witness released from the subpoena? Ms.
Yes,
Chisholm?
she is.
All right. All right. Thank you, ma'am. All right, so this time, ladies and gentlemen, because of the hour and the court is going to go ahead and let you go on your lunch break since you got here at 9 o'clock. I need you to be back here at 1:30. The court's instructions remain the same. Do not discuss the case with anyone, including each other. Keep your badges on so that if any of the persons not just involved with the case, but in the courthouse, know that you're jurors so that they don't discuss the case in front of you. Should you hear something, please immediately notify the deputy upon your return. And well, first move yourself away from the communication if possible, and notify the deputy upon your return. At this time, and also no tweeting, no chatting, and no research. I'm gonna go ahead and release you. Please take your notepads and leave them in the jury room, and we'll see you back here at 1:30. Thank you. All right, please be seated. So, Ms. Jones and Mr. Nicholson, I have provided you with the first draft of the jury charges. Ms. Jones, I did not see the state's request. I just missed it. I don't know that I saw a request for jury charges from Mr. Nicholson. Madam Clerk, do you see anything on the record? Okay, I just wanted to make sure I didn't miss anything. Obviously, we'll have a charge conference before closing argument, but I just wanted to, go ahead.
Donald, you're the
I
best.
do have them now.
Okay.
So the draft that I have was not inclusive of anything. I had not looked at this yet, but I will take a look and add anything that I believe is appropriate at this point, but obviously there'll be an opportunity for further discussion about those, so.
Thank you.
Yeah, yes, I will, yes. All right, anything before we recess for lunch? Ms. Jones? Hold on a second, hold on. Have they cleared? Hold on a minute. Oh, no, just one then, yeah, so it'll be exhibit 2. Okay, all right, thank you. Okay.
Juror's injury?
They just got stickers.
He's not coming around here anymore because of that short I made today.
All right, please be seated. Welcome back, members of the jury. I have to ask you what come to be your favorite questions. Have any of you had any conversations with anybody about this case? Have you heard anything about this case since you left this courtroom? And have any of you conducted any research or communicated with anyone by electronic means, including posting or emailing? All right, thank you. So with that, I'll ask the state to call your next witness.
Yes, Judge, the state calls Officer John Florio.
Please step forward, officer. You raise your right hand to be sworn in.
It doesn't matter what happens here. It doesn't. She's always going to hear a noise. She's always going to, when the phone rings, she's always going to, when an email comes. When she gets out of the car at night to get into her house, she's always, always, always going to. Always. It's always. This man will be in her head for the rest of her life. Like 4 years from now, she's going to get some random message from somebody because, messages happen. And she's going to be, oh, yep, that's him. It might not be him. It might be him. It doesn't matter. She's always, always, always going to think about this guy in some way, probably almost every day. Hear a noise, get out of her car and look around. Look when she gets into her car, see who's messaging her every day.
You do solemnly swear that the evidence you shall give to court and jury in the trial of this issue shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. All right, let's have a seat, please. Watch your step, and then press the microphone.
Good afternoon.
Good afternoon.
Would you please introduce yourself to our jury?
Good afternoon. I'm Officer John Florio, assigned to the East Side Precinct.
And can you spell your last name for our court reporter?
Florio.
Thank you. And you are assigned to, you said the East Side Precinct,
Yes, ma'am.
and that's with the Savannah Police Department?
Correct.
Okay, so what is your job title?
I'm a patrolman.
Okay, and how long have you been there?
About 3 years.
And are you a post-certified officer?
I am.
And what does that mean to be a post-certified officer?
I'm legally allowed to enforce the law in the state of Georgia.
Okay, so you have arrest powers?
I do.
And were you on duty on
so
January
scary.
13th of
Jeez.
2022?
Yes.
Did they get him?
Okay, and that was still at Savannah Police Department at the East Side Precinct?
Correct.
Okay, and did you respond to a call initiated by a Brianna Waldberg?
I did.
And can you tell us about that, please?
Sure. When I responded to that call, it's when I met Miss Wahlberg. She had explained to me that she had been contacted by Mr. Nicholson. She had explained that there was a protective order in place at the time that she was contacted.
Objection. Hearsay.
Overruled.
Excuse me. She had showed me email.
Lori, I'm going to hang out in your bushes for the next couple days. Don't you worry. Don't you worry none. I'm going to hang out in your bushes, and I'm going to get him.
That she'd gotten from Mr. Nicholson, several emails during that day, and one previous to that day. I was able to confirm that there was a protective order in place, and I provided her a link so you can upload that as evidence.
Okay, and at that point, did you have anything further to do with regard to investigatory activities into Mr. Nicholson?
No.
Okay, and did Detective Aiken take over?
It's
those
nothing.
duties?
I was going to be there anyway.
Yeah, that's all I have. Thank you.
Any cross-examination, Mr. Nicholson?
No, ma'am.
All right, thank you. Is this witness free to leave this time? All right, Ms. Jones. All right, thank you, sir. You may leave.
Thank you.
State's next witness.
Officer call, or, a moment, please. Thank you. Call Detective Jamaica Aiken to the stand.
Raise your right hand. You do solemnly swear that the evidence you shall give the court and during the trial is issued shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Good afternoon. Would you please let the jury know your full name?
My name is Jamaica Aiken.
And I think the court reporter already has the spelling of that. And where are you employed?
I'm employed at Savannah Police Department, and I am assigned to the CID unit as a family violence detective.
Okay, so CID would be Criminal Investigations Division.
Yes,
Did I say that right, or is it Criminal Investigative?
criminal investigation.
And do you also have or are you a post-certified officer?
I am post-certified.
And did you ever see the investigation regarding Mr. Derek Nicholson?
Yes.
Okay, and what was your preliminary involvement with this matter?
So originally, I was assigned this case due to the patrol officers actually responding to the location. So I didn't originally respond. Once I was assigned the case, I then conducted my investigation by verifying that it was an actual TPO in place. With the TPO being in place, in order for it to be valid, it has to be served and certified, which means that Mr. Nicholson had to be informed of the temporary protective order. I confirmed that the temporary protective order was served during the course of my investigation, after which I then started my investigation once I was notified of that, and I was provided, I was able to log into evidence.com and see that he contacted her after the course of the temporary protective order being served.
And that was because she had uploaded certain screenshots?
Correct.
And did you have any direct contact with Mr. Nicholson?
No, I spoke with Mr. Nicholson. I spoke with Mr. Nicholson via telephone.
Okay, so that would be direct contact?
Yes,
Okay. And do you recall on what date that was?
I do not.
Okay, would January 20th or around that date sound right?
Around that date sounds correct.
And what was the substance of that conversation?
So basically, I called Mr. Nicholson and I inquired about his contact with Ms. Walborough. During the course of our conversation, Mr. Nicholson was more so concerned. He stated that he was aware of the temporary protective order that was placed. He stated that he contacted her. I'm not going to quote him, but to the gist of he contacted her to express his feelings. He also informed me that she had his son. I then gave Mr. Nicholson I told Mr. Nicholson I understood his concern about his son, but he had to go through the court system due to the fact that his son wasn't actually legitimized. I also told him information on how to go through the court system.
Okay, and after that conversation, did you take out a warrant for Mr. Nicholson's arrest?
I did.
Going to hand you up what's been pre-marked. Oh, excuse me. One second.
This form don't got a date or a time on it when it's on the judge signed it. I just want to make sure it's correct.
Handing what's been pre-marked as State's Exhibit Number 4. Can you tell me if you recognize those documents?
I do.
And what are they, please?
They're the arrest warrants that I put in CIC/GCIC for Mr. Nicholson.
Okay, and is that the same warrant twice?
Right here, I have one warrant.
Okay, so it was returned though?
Yes, this warrant was signed by Judge Tammy Stokes.
Okay, so it was signed off by a judge after you applied for it, correct?
Yes.
Okay, and then filed with the
Hey, that's
Yes.
that judge right there.
At this time, we tender State's Exhibit 4.
Any objection?
No, I mean.
It's admitted.
Oh, yeah.
That's all I have. Thank you. I tender this witness for cross-examination.
All right. Any cross-examination, Mr. Nicholson?
It's my turn?
Yes, sir. Do you have any cross-examination?
I don't know who he's speaking to. I don't know. He might have standby counsel that Judge Tammy Stokes made him have. I don't know. I'm surprised he said he wanted to ask this detective some questions because he doesn't want to focus on the fact that he broke the law at all. Like, that's a byproduct. It's her that he's focused on.
Good afternoon, ma'am.
Hello.
When you had a conversation with Mr. Nicholson on the date of January 20th, did you record the conversation?
It was recorded.
Do we have a copy of the conversation that we can hear?
I don't have the copy. It was recorded on our Mitel. At some point, I was able to switch desks. So I did not pull it all up.
All right, so you don't have a core in the meeting. So you say Mr. Nicholson stated to you that he contacted the person? That's what you stated?
I stated that you were aware of the TPO and you did contact her because you was contacting her to express your feelings.
All right, so Ms. Nicholson did tell you that she contacted him first and that he had a text message of her contacting, correct?
I don't know if you told me, I can't recall if you told me she contacted you first or not, but I do recall you stating that she had replied to you.
Judge, I would like to enter evidence to Ms. Shamika to show the contact that was made before any contact she stated.
Okay, are you trying to tender it now, or do you want her to identify
I
it?
want her to, well, she can't identify it, she never saw it.
All right, you can show whatever it is you would like to tender to the state through Ms. Jones.
Objection, Your Honor. Foundation.
Trying to do this one.
Just that. So that paper might not look familiar to you, but on January 20th,
Judge, I'm going to object to him questioning her about this document. He's already acknowledged that she's unable to authenticate it. And he's also failed to lay a foundation.
All right, so Mr., I don't know what the document is, Mr. Nicholson, you'll need to lay a foundation, or you can ask her if she recognizes the document.
I recognize it. I'll do it on my, when I got
Okay,
it on.
all right, so you want to get that back?
Get it back.
All right, thank you.
Thank you. So Ms. Nicholson, how many times did you talk to Ms. Nicholson? Ms. Shamika?
I don't
Let me
recall,
look at you.
but
Don't
I
recall?
do know that it was more than once.
Okay, so in May, do you recall talking to Ms. Nicholson, telling Ms. Nicholson, contacting Ms. Nicholson again about the situation?
Ms. Nicholson, I don't recall exact dates. This is 2024.
All right, but you do remember that it was multiple times that you contacted Mr. Nicholson about the situation, and he explained to you that the person was contacting him.
I do recall talking to you multiple times.
Ms. Shamika, are you familiar with the constitutional rights of a citizen, the Sixth Amendment?
I am.
Judge, I'm going to make a preliminary objection. This witness has not been qualified as an expert in constitutional law.
All right. Mr. Nicholson?
Yes,
The
ma'am.
judge
I
says
guess
the
I would
law.
need to know the questions. You asked her, was she familiar?
Yeah, she's familiar with the question.
Okay.
The
What's
Sixth
your
Amendment.
next?
Oh, you say ask the question? Go ahead.
Yeah, what's your next question? I'm sorry.
I was gonna ask you, farthest. No, not the Sixth Amendment. The Fourth Amendment. Arrest without warrants. You're familiar with that, correct? Fourth Amendment.
Yes.
When did you have Mr. Nicholson arrested? On what date?
I do not have the A and B in front of me, but I did issue warrants for you, Mr. Nicholson. And DV is a warrant. Domestic violence in the state of Georgia is a warrantless arrest.
It's a warrantless arrest if you're in
Yes.
another state.
We practice as a domestic violence in the state of Georgia. DV is a warrantless arrest. This incident occurred in Chatham County, which would be a state of Georgia.
Okay, and the DV happened in January of 2022, right? That's when you stated on your warrant, on the warrant, right?
That is when I took out the warrant, the domestic, according to the reports, I went off of the times of the violation of the temporary protective order.
So from the time of January, when you stated that he violated the protection order, why didn't you get a warrant for his arrest then?
Your warrant was issued in January.
But when was it signed by a judge?
In January.
Can I see that warrant again? Because, can I, are you familiar with this? Can I, enter this to the,
Sure. Show it to Ms. Jones.
Does that warrant look familiar to you?
It does.
On that warrant, what's the date that it was signed by a judge?
On June 18, 2022.
Okay, so if Mr. Nicholson, if it was signed by a judge on June 8th, 2022, why was Mr. Nicholson arrested?
This warrant wasn't, this is the date on here is the date that they served you with your warrant, which is when you got to Chatham County. The date that the warrant was issued is January 20th, if I'm not mistaken, of 2022.
But a warrant is not valid. And I have the paperwork on it. A warrant is not valid until a judge signs it.
The warrant was signed in January.
By who?
Judge Tammy Stokes.
So why did Judge Tammy Stokes have to sign another warrant on June 18th?
Sir, she did not sign it. This is when you were served by the officer. The officer that served you, date and time, the time that they served you.
Can I see that paper one more time? I need to look at it. You're mistaken. Date and time the officer served me. Okay, so right here on the bottom of this warrant, it says, I have this date executed the form warrant on June 18th. Ms. Tammy Stokes' signature is here. So that means this warrant was signed on June 18th.
No, sir. Ms. Tammy Stokes is the judge that signed it above. Where you see it, I have executed the warrant, meaning that is the officer that served you that warrant when you were extradited to Georgia. You were extradited from Florida here. The officer that served you in June.
So the warrant was spent in June.
The warrant was entered into the system in January.
All right, so why it took so long for them to arrest me?
That is not, I didn't come get you.
So
The
the
U.S.
warrant was
Marshals
issued.
did. That's,
All right, so that being said, January 21st, do you feel, okay, Ms. Nixon did make you aware that he only contacted her about his child, correct?
you told me you contacted her to express your feelings.
Do you have the recording of that? Because that's not correct. Ms.
Objection
Nixon-
asked and answered.
Sustained.
That's not correct. That's not correct.
Well,
Objection argumentative.
you can't argue with the client, with the witness. You have to either ask another question or you'll have to present, or if you choose to present evidence to show that what she's saying isn't correct, but you can't argue with her.
Because there's no recording and she can't prove that it's correct what she's saying is neither, right?
Mr. Nicholson.
Okay, no, I'm just picking it up.
Objection,
All right.
speaking objection,
All
or
right,
speaking argument.
sustain. The jury is to disregard that last statement from Mr. Nicholson.
So if you issued the warrant and the warrant was sent and you talked to when you talked to Mr. Nixon, did you tell on January 23rd, did you tell Mr. Nixon when Mr. Nicholson finished the conversation, he asked you a question. He asked you, was he in trouble? Should he turn himself in? You told him that you don't know, you will contact him. Do you remember that?
I can't quote what I said, Mr. Nicholson. Again, I don't recall I was at conversation.
Okay, so when you called Mr. Nicholson in May, again about the situation, he explained to you that this person has continually contacted him.
Objection to the form of the question. He is testifying.
Mr. Nicholson, is that a question?
Yes. On May, when you called Mr. Nicholson in May, did he or did he not tell you that this person?
This judge will hit you with contempt. No problems, not even blinking.
Continuously contacted him?
I do not recall.
Okay. More, how to go? That's it for this witness, Judge.
Any redirect from the state?
No redirect from the state.
All right, thank you, Detective. You can step down. Any other witnesses for the state?
No, Judge, the state rests.
All right, thank you. All right, ladies and gentlemen, I have to give you another break at this time. So I'm going to ask that you retire to the jury deliberation room and continue to follow the court's instructions. Please take your notepads with you. Follow the court's instructions and that you're not to discuss the case, no research, no posting, no texting. Thank you. Please be seated. All right. Thank you. Mr. Nicholson, as I mentioned to you prior to the start of the trial, I went over your right to testify and your right not to testify.
Oh, yes.
So I'm going to
Yes,
go over
he
that with
does.
you once again, except this time I will ask you if it is your desire to testify. So do you understand that you have a right to testify, and if you want to testify, no one can prevent you from doing so?
Yes, ma'am.
Do you understand that no one can make or compel you to testify?
Yes, ma'am.
That is, do you understand that you have a right to not testify?
Yes, ma'am.
Do you understand that you and not your standby counsel, but you personally are the one who decides
And there we have it. The person he was speaking to was his standby counsel.
whether you will testify or not?
Yes, ma'am.
Do you understand that if you do not testify, and I have already instructed the jury of this, but will do so again, that the jury will be instructed that your decision cannot be used against you?
Yes, ma'am.
Do you understand that if you choose to testify, you will be subject to cross-examination by the assistant district attorney?
Kathy cannot confirm nor deny whether this may or may not happen.
Yes, ma'am.
Do you feel that you need additional time to think about whether you want to testify or not?
No, ma'am.
All right. Do you personally want to testify?
Yes, ma'am. And Judge,
Okay.
I'm moving for a direct verdict to count
Okay.
one, insufficient evidence.
Okay, count. Well, the sole count in the indictment? All right.
Okay, he's going to testify tomorrow, guys. We're going to hear him tomorrow, guys. And it'll be great. I love pro se. Oh, man. Security, we can't play it all in one day. It's too long. It's just so much goodness. Yes. It's too long. We'll be here till tomorrow. Okay, I can play it. I did not edit it. I can play it. I just have to get it. Okay. I'll play it. I'll play it. Give me a sec. Give me a sec. I was ready to go into Judge Fleischer. I think it's here.
The voluntariness. Take it out, okay.
Okay. I know this says it's 5 hours and 45 minutes, but there's breaks and stuff in there. This is not 5 hours. But we can't play the whole thing today, but we can play him. I have to find him. Okay, so this is where we just left off, I'm sure. Wait, she doesn't have a blanket on. Last person up was the police officer, so we're ahead of this. Oh, that was the verdict. I'm glad I didn't play that. That was the verdict. That's the verdict. There we go. So this is 6 hours long, but don't worry, don't worry, don't worry. It's not really. Did we see this person? Yes, here we go. For the record, you asked for this. Here we go.
I'm sorry.
Can I step out, please?
All right. You need a few minutes?
2 minutes.
Okay, all right.
Of course, so we started this whole trial on day 1 with him asking for a continuance. So
right.
now he needs 2 more minutes. I'm going to try to fast
If you all
forward 2
want to
minutes.
stand and stretch for a minute, you can.
No, I don't want to
Just stay in
stand.
place.
Standing is too hard. There he goes.
All right, Mr. Nicholson, so the record is clear, before you begin, will you state your full name?
Derek Lamont Nicholson.
All right, and then you can just speak into the microphone and tell the jury what it is you'd like to tell them, sir.
Am I able to tell my story of what happened
Yeah,
to me?
this is your testimony, and then you'll be subject to cross-examination.
Yes, ma'am. Me and Miss Brianna met.
Well,
Ma'am?
Mr. Nicholson, you need to stay within the scope of relevancy to this hearing, to this trial, though, okay? I just heard you say, could you tell about?
The trial, wait, that's what I'm trying to understand. Like, from the beginning of the situation when we started, I can't talk about that, what she said about the
Mr. Nicholson,
abuse?
do this. You go ahead and begin your testimony. If there's something that I need to address, it'll be addressed, okay?
I think he's out on bail.
No. I met Miss Brianna Wahlberg June 2020, June 19th. No, June of 2019. Me and Miss Brianna dated for maybe 2.5 years. From the time of us dating until the time that we moved together, Miss Brianna Wahlberg choked me. She would slap me because I would say something that she didn't like about just situations. And I sit there and accepted it. Moving forward, Miss Brianna moved out my house May 28th. But me and Miss Brianna she kept coming around because she had my child. And I didn't care. I wasn't trying to see nobody else. I just wanted my child to be able to come to my house all the time. So I didn't mind her coming to my home. On October 26th, you will see in this video that we're gonna play. This incident will show just me sitting here and this woman coming outside. I was on TikTok, just trying to grow my page, and she came outside and just started an argument. And this video will show that.
All right, so you're asking to
play the video.
Are you?
No,
first you have
he
to
didn't
tender.
ask that.
You're asking the tender.
I'm asking the tender the video. Yes.
Is this Defendant's Exhibit 4?
Yes, this is Exhibit 4. Is it, what is this, 4?
If I may, it's Defendant's Exhibit number 4 that Mr. Nicholson has asked me to play, if I may publish to the jury.
All right, any objection to the exhibit, Ms. Jones?
No, Judge.
All right, the defendant's exhibit 4 is admitted and you may publish. If you will make sure that that.
Hi,
is,
legal.
fine.
In keeping with our prior conversation with the court about.
Let's stop it. Yeah, 133. Thank you.
And Your Honor, the court would please instruct the jury if they're not able to hear. I'm going to keep the volume pretty low, but
All
I
right.
can always very high.
Well, hold on a minute. I'll let you get them right after. So if any of you cannot hear, please signal and we'll turn the volume up, okay?
I cannot hear.
You fucking.
2 years of what? 2 years of what? 2 years of what, man? I'm gonna break that down to somebody for real. 2 years of what? A dude saying something to me and me hitting him. No, you be crazy. I'm trying to say something I can't. My baby just talking something. You beat me. I cheated on me. Ain't beat on shit. Nigga mentally fuck with me every time.
Nigga, you was already fucked from that 2 years. Shit, I was good.
No, he wasn't. No, he wasn't.
Good.
So your problem
I
is
was
I know
good. I was good. Nobody was hurting me.
good.
Nobody was hurting me when I was.
relationship with a nigga that had another chick.
And I had love it. Man. The fuck? I loved it when it was that time. What the fuck you mean? Yeah.
You want to see what you
I'm as confused as you are.
Yeah.
For the record, Your Honor, Mr. Nicholson has indicated to his standby counsel to pause this video at 1 minute and 24 seconds, which is prior to the requested time frame.
Okay. All right. Thank you. Mr. Nicholson, you may continue.
At this time in this video, Ms. Walbert was not staying with me. Ms. Walbert left my home, like I say, May 28th. She would come, she would stay, it was no problem. This day, maybe 4 o'clock in the morning, she stayed in my house. I got out of bed because I didn't want to disturb her. I went outside
Now I don't like him.
to just play on TikTok, just to grow my page. She came out there, started talking, and you see the video. From that point, Miss Barbour left. Miss Barbour had no clothes or anything at my house. She was gone. She just woke her kids up. She woke her kids up. I asked her in the video. I didn't show that part, but in the video, I asked her. I told her, man, please, I'm gonna go to work at 6 o'clock. My daughter, I have to drop off to school at 6. I have to be to work at 7. So you can just wait. You know what I'm saying? Don't go wake your kids up. Don't go in the house making a noise, interrupting the kids. You know what I'm saying? You just wait till you I leave, and then you can just go and never come back. Ms. Walbert left. From that point, I need my paper because I would like to show the interest something.
All right. Ms. Walker, are you able to bring his papers to the stand? Thank you. Thank you.
The glasses also, I can't see. Just that, just the podium.
Yes, sir. May I have correct, Your Honor?
Yes.
Thank you. Can I go to the state and give them this?
If that's something you want to tender?
Yes.
Yes. Well, just ask.
Tender.
Thank you.
If I may, Your Honor.
All right. Thank you.
All right, just another question, another besides what's going on here question. Sort of, okay. I know when you get a private lawyer, they sort of keep stats, how many cases won, how many cases lost. Do public defenders and prosecutors also have a, status? How many do they keep track? Does it mean anything? Is it meaningful at all? How many cases a public defender wins or loses? Like it is with, so like if you go to, get your own lawyer, you want to know how many cases they won and how many cases they lost. That's great for their marketing, to pull in more clients, blah, blah, blah. Public defenders don't have to actually do that. They just are gifted clients. But do they keep track? And on top of that, if you are a standby counsel and you have to deal with him as the lawyer, does that go against your record? Do you have a record for that? Tokyo, make it green. Thank you so much.
Are you asking that to be?
Someone named Chicken Cakes was just gifted a membership. And I just hope that someday we get to meet Chicken Cakes. Chicken Cakes, you have got to come in here because it sounds like by your name you would fit in well.
Marked?
Yes, mark as evidence, what, 5?
Would be Exhibit 6. Any objection?
Yes, Judge, we're going to object based on relevancy, and we're also going to note that this was not previously provided to the state as part of discovery.
Okay.
But it's, I believe, dated October 26th of 2021. Again, it's way outside the scope of the matter before the board.
Okay. All right. And what would be your purpose in
Judge,
tendering this?
she
Be right
stated
back.
the situation on the 26th, and this is just to show that I was the one that, I don't know the word, I told her not to contact me anymore. I told her to contact me through email.
All right. I'm going to allow it over objection. It's marked exhibits. We need to get it marked, Mr.
Sticker prepared, Your Honor.
All right. Thank you. So defendant's exhibit 6 is admitted over objection.
After day 26, when Ms. Ballbird left, I told Ms. Ballbird that I don't trust her. You know what I'm saying? Because we went through the situation before when Ms. Ballbird, she got caught cheating. And when she got caught cheating, this was before we had the baby. Didn't put my hands on her. Ms. Ballbird left. And when she came back, you know what I'm saying, I just told her that it was no use for us to, you know what I'm saying, I don't want no communication with you no more, because she went and told the police, she went to make a report of a protection order because she cheated on me. I never did anything to her. The report never, she filed the report for the protection order.
Judge,
She never went to court.
I'm going to object. This is an improper line of, I guess, testimony, not so much questioning, but testimony, because again, we're not here to litigate the appropriateness of the TPO, whether it should or should not have been issued. So it's an improper argument he's making, and this line of questioning is irrelevant.
All right. Mr. Nicholson, I tend to agree with the state. Tell me why this would be relevant to the issue that is to be decided today, which is whether you violated the protective order that was issued.
I mean, this is just bringing on this person and who she was, like the person I was dealing with, and that I was the one that initiated the stay away, like for us to stay away. But
okay, I'm going to sustain the objection, and you can move on to another line of testimony.
So I can't use this.
Well, I've already admitted the.
Oh, so I can read it?
No, because it's been admitted into evidence, it'll go back with the jury.
Thank you, Crystal.
That document right there. So if you'll hand it to the deputy or the clerk, if you, thank you. All right.
All right, moving along. 26, that letter. From the 26th of October all the way to, I'm gonna say November, the beginning of November.
That was a great one, Crystal. That was a great one. You got JoJo and J-Fire. Green. You got them green.
November, me and Ms. Wahlberg transferred text messages back and forth. During the text messages, Ms. Wahlberg me and Ms. Wahlberg got the child in school, in daycare. We wasn't contacted, we only text message, we only contacted through messenger, through email. When she got the child in daycare, I made it to where we can't see each other because I didn't want no problems with this lady. So I was able to pick the kid up from daycare and drop him off, and then she'll pick him up. A certain week came around right before Thanksgiving where I was going to be off 3 days. I hadn't seen my child for a month and a half because Ms. Wahlberg took him from me and told me that I wasn't going to see him no more. I was able to get my child for the first week because it was COVID. I was able to get my child, and then the next week, because of a fever the child had, she wasn't able to leave him to the school. So she basically told me that come pick her up from her, and I told her I wasn't coming. That made her mad. The following week, I called Miss Brianna. I asked Miss Brianna, man, please, can I get the kid? It's going to be on the weekend. She said no. I got upset. And I went to the only output I had, and I made a TikTok video. I never said anything about who this person was, what the person did, or anything at that time. This was before the protection order, which is correct. I never said anything. Told her. I'm sorry, I'm scared, but give me a minute. Oh, so we got the kid in daycare. She got mad.
Karen.
She wouldn't let me see my child. I made a TikTok video. I would like to present this evidence. I mean, so for what I'm saying, just to bring back to the jury. Ms. Brianna Wahlberg made a message, sent a message to me and said, person, nigga, if you since you want to go make TikTok videos, you need to send your daughter back to Miami because I'm going to the police. I had not seen Miss Brianna Wahlberg for almost a month and a half. No, only contact.
Again, I think the court's already ruled that this entire line of testimony is inadmissible about what led to the TPO, whether it was appropriate for a TPO to be issued and so forth.
Can I answer the evidence?
Mr. Nicholson, the line of testimony you're providing these incidents, is this before the TPO was issued?
I mean, it is, but I'm just
Okay.
speaking to the jury of how this person, you know what I'm saying, how we're treated by this person. If I can't tell you, if she was able to sit up here and tell the jury about things that were lies that happened, why can't I go to the same point until we get to the end like she did? Because I'm the witness here, man. I'm just trying to be treated fairly.
Mr. Nicholson, I understand I've allowed you some leeway, but we're not going to go through every ins and out of the relationship because that is not relevant. So I'm going to sustain in part the objection. You've testified as you've testified.
This in for the
I'm
jury
not sure what that is, so you'll have to let me
jury.
give it to Deputy Casper so she can show it to Ms. Jones.
Judge, I think the court has been very generous and gracious towards Mr. Nicholson in allowing him to admit exhibits that are strictly speaking not relevant to this issue at all. And again, I would note that none of these items were provided to the state as part of reciprocal discovery prior to today in this moment in time. But all of this still goes to issues they were having back in what appears to be October of 2021, Judge. So we're going to object to relevance.
All right, and the TPO in this case was issued,
On
this is
December-
prior to the TPO?
It is, Judge. The TPO was issued, the 12-month one was issued on December 15th
Okay,
of 2020.
all right. So in these two items, Mr. Nicholson, are two separate items?
They basically what I just stated, yes. They two
Okay.
different items. I guess.
All right, so I'm going to sustain the objection, Mr. Nicholson, because we're going to go far afield, but I'm going to go ahead and have them marked. So for purposes, if you want to appeal, if you'll hand them to the deputy, and those can be marked at, what number were we at? 7? Okay, you can mark it as one exhibit. Exhibit 7 is not admitted. All right.
All right. On December 20th, Foster's Warren State, I committed this crime from the date of 12/27
True.
12/27 to 1/17. Father Warren said, I have emails from Miss Brianna on 12/20 contacting me before the detective was ever contacted about anything. Can I can I put this in the evidence since this is?
Hand it to, anything
All right,
you want to
anyway.
tender, Ms. Jones needs to see it first, okay? So hand anything that you're seeking to admit to Deputy Casper to show Ms. Jones.
I am never displeased with Fozzie. Yes, Monica, he's writing a handbook to victimhood.
Okay, Judge, I appear to have been provided with copies of email change from 3 different dates. I don't have an objection to any of them. However, I would ask that they be marked appropriately. It looks like the first set would be from 12/20 of 2021. And then there's another set from 4/18 of 2022. And then finally a set from 5/17 of 2022.
All right. So, Madam Clerk, if you will mark each set as a separate composite exhibit. So I think we're up to 8. Is that correct? Yeah. So defendants exhibits 8, 9, and 10 are admitted. It's 3 different sets, correct? Okay. All right, any further testimony, Mr.
Yes, ma'am.
Nicholson?
I would like to admit this. Oh, wait.
See, this is what happens when I don't get to edit the video. I'm gonna bump
This
it.
just showing.
Nope.
Hold on.
I'm gonna bump it 30 seconds to give her time. I don't think Fozzie's here, Lacey. He's sleeping. He went on nights. He's sleeping with the fishies.
there's
Any
been a
objection?
foundation laid, I understand that I was shown some documents.
Okay, Mr. Mr. Nicholson, so you need to lay what we call a foundation. So without giving the specifics, what is that? Is it an email? Is it a?
These are emails that were sent between the dates that the detective stated of contact. These are emails from me to the defendant, which states to the victim.
To Ms. Wahlberg?
To Ms.
Okay.
Wahlberg. These are messages from me to Ms. Wahlberg. The messages are left out. Ms. Wahlberg used the app to delete her messages, so I wasn't able to get the messages that were responding to my messages from from January 1st all the way till January 20th. I wasn't able to get those, but these messages would show that.
Okay, without telling me what they show, tell me again the dates.
Of what?
The messages.
These dates are from 1/7.
What year?
2022. Okay. Right after the protection order started.
Okay. Ms. Jones, any objection?
No, Judge.
All right. So this would be, it's one set. Okay, this would be Defendant's Exhibit 11, and it's submitted.
Okay. Okay, hear me out, because I think what he just did was pretty good. Just hear me out. I know nobody likes him, but so I have a protection order against, let's say Fozzie puts a protection order out against me, and I'm not allowed to contact Fozzie, right? But then Fozzie emails me. Now that, in the technicality world, that shouldn't matter, all right? But people are people, and Fozzie reaching out to me and me not replying would be hard for me to do, because I would feel like it would just be hard for me to do, right? So if she contacted him over and over, or once, or whatever, and he replied, he's wrong. He's definitely wrong. Okay. But it might mitigate his sentence. So instead of getting 40 years in jail, he may only get 20 years in jail if this is a mitigating factor. So maybe, he's already admitted that he contacted her every which way. They already have, all the evidence that he's emailing her and on her TikTok, blah, blah, blah. So what he just did, I think, was pretty good, because maybe this might mitigate his sentence. Who knows?
All right. So, basically, the messages was show that I never said nothing to harass or intimidate the victim. Every time I contact the victim, we was talking about my child. Some of the messages I can't say taken out of place, but because of Miss Wahlberg, she made it difficult to be able to co-parent and to get her to go do the right thing. I left Savannah, Georgia, because I was put on a protection order. I had to leave my home. I was within 500 yards of her job and her son's school. So I had to leave my house, 3-bedroom home. I went homeless. I moved back to Miami, and I stayed homeless for about 2 months.
What is your son's name?
Ms. Wahlberg was contacting me. You know what I'm saying? I contacted her, but it was about my child. All I wanted was her to just go do a DNA test, because a judge told me I wasn't legitimized. The judge didn't give me the opportunity.
That's 100% true.
What was going on? And I just wanted my child. I just wanted to be in my child's life. I have raised 3 kids. 1 child made it to college. My son,
Name them.
First Nicholson, go college. You know what I'm saying? And I just wanted to be a better parent. My son told me that he felt like I didn't do enough because I worked 16 hours a day just to make sure they was good.
And you're homeless.
And I didn't have the time, I guess, to go to every football practice. So now, being of age where I was making a little bit more money, I go to my son's game now. I just wanted that chance to do it again. But Ms. Wahlberg contacted me through this whole situation. You'll see in the evidence that she taunted me, talking about her family going on my TikTok. Oh, all you got is TikTok, it's in the evidence. And but moving forward, I never meant no harm to Ms. Wahlberg. Ms. Wahlberg has been doing this to me since we started. Every time she doesn't get her way, she acts out. I have never been convicted of no domestic violence. I never hit nobody. I am a convicted felon for my own reasons, because I was a child growing up in the hood. But I changed my life. I've been working for 20 years straight, ain't been in jail, besides the DUI that I ain't do. But I just wanted to be with my child. I didn't do nothing to this lady. You've seen the evidence of the text message. There was nothing in there to put that lady in harm. I'm going to show you a video of the officer coming to her home. I guess on whatever January of 2022. In this video, you will see that this woman never told the officer that she was afraid for anything. She basically stated about my TikTok videos. That was it. My TikTok videos, which is my First Amendment right. I had nobody to talk to but TikTok. She took my child away from me.
Cry all the time.
And you helped her.
All right.
I'm done.
You need a moment?
No, I'm done. I ain't got nothing to say, man.
All right. Were you asking for
No,
the
I'm
video
finished.
to be published?
Ma'am, no, I just pray. I mean, I got closing argument.
Okay, hold on. You mentioned the video. Do you
Yeah. Oh, yeah. I
want
need
the
to play
be
video. Please play
published?
video.
Okay, so this, I believe, is Defendant's Exhibit 5. Is that correct? Madam Clerk, the other video? All right, Ms. Walker, if you'll assist in publishing that to the jury.
Yes. I'm trying to make sure I'm publishing the right exhibit. I know it's 5, but that is the 30-second clip, correct?
The 30-second. No.
I think, and I might have this backwards, I think her lawyer's name is Wahlberg and her name is Walker, or her name is Walker. And so I think they keep messing them up just to confuse us more.
No, that's not that one yet. You know what? Play the 30-second clip.
Ms. Jones, just so the record's clear, any objection to Defendant's Exhibit 5?
I'm gonna punch him if he snaps
The one
again.
that I was previously showing.
I'm gonna snap if he snaps again.
You can go ahead and play the 30-minute portion of Exhibit 5. I should say 30 seconds, excuse me. I said 30
Listen,
minutes.
don't give me ideas. I have no self-control.
Correct, Mr. Nicholson, is what you'd like to publish, correct?
Yeah, I think so. Yes, yes.
And do all this stuff to me, and then tell somebody you're afraid of me. You should be afraid of me. You just took everything, bro, for your own happiness. Everything. I didn't do nothing to you. I didn't deserve this. Why didn't you just leave me alone? My nigga, why I had to be in your plan? Why did I have to be in your plan? I didn't do nothing to deserve this, my nigga. I can't even get this shit back, bro.
That video was
See what happens when you guys don't let me edit? That happens. You should be afraid of me. Did he just say that and then play it for the judge himself? Judge, I want to play you this clip. Maybe he's trying to intimidate the judge right now. Maybe. When he said, you should be afraid of me, maybe he's thinking the judge will think, oh, I'm sorry, Nan. I'm sorry. I didn't edit this. I blame you all.
a post that I made on my TikTok page. I guess that's how the state got the TikTok video from going on my public page and taking my information, because I never sent anything to this woman. They went to my page and they were watching me. Just, I don't even know why. But I would like to move on to the next video, Judge, to show that this person never told the police she was harmed. She just sat there and told the police that she was mad about me about TikTok videos. This woman know I moved back to Miami. She knew because we had conversation and I told her that I wasn't there no more. I made the videos in order for the people in Savannah to know that I was no harm to this lady. I wanted them to know that I was no longer in Savannah. That's the reason I made most of the videos and I posted them, because my road travel back home, my whole experience and me being in Miami, I made a video every day so this woman wouldn't lie and say I came near her. But play the video.
Excuse me, Judge, I have not seen a third video.
It's let me have the jury
This
step out
your
for a
video.
moment.
Oh, go ahead.
Hold on. All right, ladies and gentlemen, I'm going to give you a brief recess. If you will retire to the deliberation room, no discussions, no research, no posting about the case. And if you overhear something, let the deputy know immediately. Thank you. All right, you all can be seated. Thank you.
That's what he did. Now, I don't know if he actually did this on his TikTok or if this was the video that he put in her TikTok on a comment that someone else made to hers. I'm going to say that from now on. I don't have any Canadian in me, but he's annoying the Canadian in me. I'm going to post this TikTok on my TikTok page. I do have a TikTok page. I tried. I made an effort. I should do that. You think? You think? Play the video.
Madam Clerk,
Make my dinner.
get that back to you. Thanks. Before I mess it up.
Yep. Abso-freaking-lutely.
Can you do me a favor?
I would never ramble. I would never ramble on and on social media. Violation, violation, violation. Me too. I have so many things to hide wine, so many different items, like a bag in like in the lining of a purse with a little spout that comes out of the side of a purse, bra, like tumblers that look like coffee cups. I have so many different wine things. People just keep buying them for me for Christmas, my family. I would definitely drink vodka if I was the court reporter because it doesn't smell. Like you won't smell. I'll smell a lot like alcohol if you just stick to vodka. The more you know. I don't know what smells the most. I guess bourbon would probably smell the most. If you got pulled over by the police. Yep.
With respect to
They're kinda
the
cool.
video, Ms. Jones, well, first of all, Mr. Nicholson, you're still trying to show
Yeah.
this video?
If I may have Mr. Nicholson's, I apologize, to interrupt the court. May I have Mr. Nicholson's permission to show Ms. Jones the portion of the footage? that
Are you-
was addressed?
Yes.
All right, sounds like he's granted your permission, Ms. Walker. Do you want to step down to, are you for it? Pardon?
That's the information they gave to me.
Oh, I understand.
Oh.
If it's red wine, it doesn't need chilled. Oh, I've never had Japanese beer. Googling on Amazon.
Recordings at this point, but I believe it would be an accurate statement to say that I have at least shown the state from 1 minute, and we have not played the whole footage, but from 1 minute and 7 seconds, where an individual who I believe is Ms. Wahlberg is walking out of a home, is speaking to police officers up until 7 minutes and 15 seconds of that video where that contact terminates for a period of time. So I believe that is what he authorized me to show.
Is that correct, Mr. Nicholson?
Yes, ma'am.
Does the state have any objection to showing that portion of the video?
We do, Judge. He is not the proper witness to admit this evidence. We had both Officer Florio on the stand and Ms. Wahlberg on the stand. Either of them could have authenticated that, but this would not be permissible to be introduced with this witness.
Well, is it your contention that, well, let me ask, was Mr. Nicholson, were you there when that video was
I was
taken?
No, that video was from the post.
No. Listen to my question.
No.
Were you present when the video was taken?
No.
So you're not in a position to say whether that video shows what it purports to show?
That's the discovery that was given to me. It's the state's
No,
evidence.
I understand that. This is what I was trying to explain to you before, that there's a way to do this, and sometimes non-lawyers don't understand. So what I'm trying to understand is whether you're in a position to authenticate the video. And if you weren't there, and I'm not sure what it shows, I don't know where the victim, Ms. Wahlberg was coming from, and so you're not the witness. You may not be the witness to get that in. If you want a moment to consult with Ms. He can step down. I'm going to take just a quick recess. Give me just a moment.
What are we thinking about this Japanese beer? Should I try it? It's from California, but if American no-name brand, that's not helpful. I need more words. No, not this one. Okay, not this beer. Got it. If you give me a name of a Japanese beer to look for, I will look for it. Kirin is that dry stuff, Donald? Is it that dry stuff? Oh, light beer. Donald, what are you doing to me? Oh, here we go. In stock, free delivery. Let's try this one. Are you at least 21 years of age? Very funny. Special reserve. How about this? Does this look like a good one? Even Myco Psycho said Kirin is a good one. Is Sapporo beer Japanese? Legal said that's good stuff, but is he talking about Sapporo or is he talking about Kirin Special Reserve? I'm getting this. I'm getting both Sapporo and Kirin. We'll have a beer tasting. I'll make my own flight. So if you don't know what a flight is, which you probably do, but some people don't. A flight is when you get, like, instead of 1 pint, you get like 4 5-ounce pours of different kinds of beer. So a pint is 16 ounces, a flight would be 20 ounces. So if you ever have a choice to get a beer or a pint, you get more ounces in a flight, but they're just little shots of beer. I'm gonna get both. Kirin and Sapporo. Sapporo sounds Mexican, so I need 2 more beers for my flight, so I'm gonna go with 2 different Mexican beers. That's what I'm gonna do. Okay, let's get back to this. We're working people. Stop talking about beer.
Yeah, pardon me, I'm
Whoa, whoa, whoa.
Want to seek
Hold
state
on.
still objecting to the admission to it, I guess.
Here we go.
All right,
Put that
counsel,
low.
with respect to this video, for purposes of the record, I'm going to refer to it, I guess, as Defendant's Exhibit, what is this, Madam Clerk? 12. The state is still objecting to the admissibility
This could take
of the
hours.
video. All right, Mr. Nicholson.
I intend to bring, call Detective Atkins to the stand later.
Okay,
And she was the case detective
okay.
on this case.
So you want to seek to authenticate the video through
Yes.
her? Okay, so do you have any further testimony at this time?
Let me make sure.
Your testimony?
Yeah, pardon me, I'm trying to make sure. Give me-
Okay.
Detective, what she did. Guess that's the woman closed arguments. No, ma'am.
All right, so you stay there because you're subject.
And one more second thing also though. I would like to offer more information. I like fathers the events from October
What year? Please tell me the year.
2021. October 2021, October leading up to the protection order. Events in late October are relevant as in impact victims' credibility. As to her motive to seek a TPO goes to the essential elements that contact is harassing or intimidation.
Okay, all right, Ms. Jones, so basically you're saying you want to be allowed to testify to events from October 2021 leading up to
The
the
TPO.
protective order being
Yes.
issued, which was December
15 of 2021.
21. All right, Ms. Jones.
I think the court's already ruled on this line of testimony, Judge, as being outside the scope of why we're here. The essential elements of this particular case do not have to do anything to do with the reasons why the TPO was sought. It's about whether a TPO was issued, if he was served with it, if he violated it.
Well, he indicated he wants to show this for purposes of attacking her credibility. I will allow him to do that for that limited purpose, but Mr. Nicholson, you have to keep your testimony. And so I'm overruling the objection from October 2021 through December 15, 2021, or anything after.
All the way
But-
past the.
but yeah,
so
but don't
from
go
that, back
before.
for that. Cool.
Okay, all right. Anything else before I have the jury come back?
No.
Okay, all right. Let's have the jurors come back in, please. Mr. Nicholson, you can sit and get your things together while you're on the witness stand. I don't usually have to. Okay, that's fine.
Serious injury?
All right, please be seated.
That sounds
Welcome back,
so
members
cool.
of the jury. I have to ask you the questions. Have any of you had any conversations or overheard any conversations about this matter? Any research, any posting, texting, emailing about this case? Thank you.
TikToking.
Your response, Mr. Nicholson, you can resume with your testimony, sir.
I would like, I don't know if I already entered this in evidence, but I want to enter that.
Judge, I am juror number 4, and this man has TikToked me 7 times while we were on this break.
Whole thing into evidence to let them see.
Okay, I'll let the
It's
state review
from
that.
October 26th all the way through 22 of probably May.
May of 2022.
Yes.
Okay.
I lost focus and I have no idea what's going on right now. I'm just going to tell you. Should I fast forward? What's happening? I'm just going to bump it 30 seconds and see what happens.
Judge, there are numerous pages here. One is from an email dated March 6, 2022, which is not what he just laid the foundation for. And then there is a set of emails that
They're on your head.
it appears to involve a totally separate person, not Ms. Waldberg. So those I'm going to object to. The remainder, I have no objection to.
Okay, so that, if you'll hand that, so that would be Defendant's Exhibit 12. They're admitted. Mr. Nicholson, if you're still seeking the admission of those two items, you'll need to tell me why I should admit it over the objection.
3-6 is after the TPO.
That's the document from March 26, 2022. Is that between you and Ms. Wahlberg?
Yes.
Okay, is that,
That needs to be admitted as a separate exhibit, Judge.
Okay.
It's not part of the October batch.
okay, I'll admit that as Exhibit 13, if you'll give that to the deputy. Thank you. So that's Defendant's Exhibit 13, and it's admitted. And that's the March 26, 2022 document.
March
Okay.
22nd.
22nd, excuse me. Is that what you have, Madam Clerk? I just want to make sure you have the right. The last document that was given to you, is it? Okay, thank you. All right. And then that last document, is that between you and someone other?
No,
than-
this was between this past that date, so.
Okay,
I can't even
all right.
say.
All right, you can continue with your testimony, Mr. Nicholson.
Basically, the information that I just provided to them are messages before the TPO was entered. The messages of, me and this person going back and forth. The messages that she wrote, you know what I'm saying? Some of them were, it was about the child, about her cheating on me, or about other things. I think it's one even about when she stated that I never hit her. And that was in.
Hold on, sir. I was at work the other day and we sell wings with our beer. So we have a lot of wet wipes, moist towelettes. I hope you guys call them the same thing. Little squares, you unfold them, they're like wet napkins. Anyway, so I was at work the other day and I was refilling our containers of wet naps from the box. So I reach into the box, I scoop a whole bunch of wet naps, and out from the box comes my glasses that I lost like months ago. Yeah, I lose my glasses all the time.
That was at the end of the relationship after she left October 26th. So from October 26th, from the day ahead, if I abused her, why didn't she state that after the fact, you know what I'm saying, of going on this protection order? Why didn't she, you know what I'm saying, why didn't she say that I never hit her? Then she said, oh, maybe that was at that time. Like, where was all this information? If I was abusing you, why would you sit and take this
Judge, I'm
abuse?
going to object to him making basically a conclusory argument.
Okay,
Oh,
Mr.
yeah, that's
Nicholson,
what-
right, there's a difference between you testifying and arguing. So you can testify as to what you know.
You know what I also do? I also, not so much to men. I'm sorry, I don't know why they don't appreciate it. I don't know why, but a lot of times I just I give the women who bring purses in, which are all of them. Here's 2 for your purse. Here's 2 for your purse. You can use those later. Everybody needs 2 wet naps in their purse at all times.
Facts as you see them, but not making an argument about what those facts show. Do you understand? Okay. Well, I'm sustaining that objection. Okay.
All right, so the information she texted me, I can't talk about her. I went blank, but I think I'm done.
Okay, so
Do you want to know why? This is a public service announcement. Just listen. They absolutely have hooks under the bar. We made sure they have hooks under the bar because do you know how many men who sit at a bar? It has to be men. I guess it could be women, but I don't think so. But fine, fine. I'm sorry. Do you know how many people who sit at a bar just they don't feel like getting up to go to the bathroom? They just like let it go right at the bar floor. They just let it go right there. It's like they're covered. No one can see them. And that happens. So never put your purse on the floor at a bar. Never, 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 never. Casey Carey, thank you so much. Who got it? Love you, mean it. Aw, love you, mean it. Got it. They're green now.
does the state have any cross-examination of Mr. Nicholson?
Yes, Judge. Mr. Nicholson, you admitted to being a convicted felon, correct?
Yes, ma'am.
Okay, and can you tell us about that? How many convictions have you had?
Shoot, convictions, maybe 5.
Okay, and was one of those convictions for aggravated battery,
And what year was it?
1995, would that be right?
Yeah, I was like 14 years old, yes.
Okay, battery upon a school district board employee,
Yes.
and aggravated assault with a deadly weapon?
Yeah, he was a big man and I tried to hit him with a stick because he was beating me up. Yes, that's correct.
Okay, and you've also had convictions for possession with intent to distribute cocaine and marijuana, have you not?
Yep, I was on drugs.
This time, state would seek to tender State's Exhibit Number 5, certified copies of Mr. Nicholson's convictions.
All right, let Mr. Nicholson see those. Thank you.
Wait a minute, ma'am. These got charges I wasn't convicted of on here.
I think the first 2 pages, if you go past that, there's individual
Oh,
certified.
if you're going to give this to the jury, why would you put stuff that I
Hold
wasn't
on.
convicted on?
Let me see. Excuse me.
Sorry.
And Judge, I'm fine removing the first 2 pages. There's, I think, multiple names on there. The rest should all be Mr. Nicholson's convictions.
Okay. All right. Let me get the clerk to remark this. Thank you.
I have a sticker, Judge.
Love you, mean it came in. Hi.
You can give that back to the state. Thank you.
That would have been defamation, correct, ma'am?
Mr. Nicholson, let's just stick to the, and then I'm gonna have her give that back to you so you can finish reviewing State's Exhibit 5, now minus the top 2 pages.
Oh, I'm not muted. Sorry.
It still say cocaine and firearm carry. I never did those things.
Review them and then you can tell me.
No, read them out
After
loud.
each.
Read them out loud. All right.
You know what? Put it in. That's defamation of character because I never did these things.
Okay.
And if she's going to sit there and try to taunt the jury, that's
So do you have an objection to the exhibit?
I have objection to the exhibit. I didn't do these crimes. These crimes I never was convicted for doing.
All
I never
right, are
did.
you saying you're not the person that's listed in the documents?
This concealed firearm carrying.
Hold on, before you read them out, let me do
Read
this.
them out. Read them out. Read them out.
Mr.
Read them out.
Nicholson?
Yeah.
This turned into a defamation case. read them out. I will. I could look him up and read them out right now. There's too many to read out. The judge just keeps going. You are deflaming my character. Yes, that's exactly what he said. But he here,
Ms.
you tried to make
Jones,
the
I'm gonna
judge
have
take
to
it.
ask, on one of these documents, the name is cut off at the top. I'm not certain. All right, well, let's take these under advisement, Ms., and I'll give you an opportunity to finish your cross-examination. Do you have any other line of questioning, Ms. Jones?
Videos that you, briefly, Judge, thank you. Videos you played, and one of those, Ms. Waldberg is saying that in her previous relationship, she'd never been hit. Do you recall that?
In the video I played,
Yes. The one with the front porch?
I don't recall her saying that she never been hit in no relationship. I don't recall that.
That she had not been hit in her previous relationship?
I don't. Oh, the video on the porch. No, that's not what she said. I don't think she never said nothing about me hitting her period in that video. I said that I wasn't. I didn't hit on anybody. She said that we need to rewatch the video because I don't remember that. I missed that part.
Is it consensual education?
I think the exact quote was, "Nobody was hurting me."
And when you use the term hurting, with Ms. Wahlberg, she will manipulate words and she used words like abuse. And in abuse, when you use words like abuse, somebody's first mind would be somebody hitting you. But she'll say, my abuse will be mental abuse of me telling her to please help me or please, you know what I'm saying, do more. That's the abuse. I never, you know what I'm saying? No, that was not correct.
So
Never hit Ms. Wahlberg.
there was a petition for a temporary protective order filed by Ms. Waldberg in December of 2021. Do you agree with that?
Yes, ma'am.
Okay.
2021, yes. That was on, no. It was what? December 2021? Ma'am, you correct?
Yes.
It was a what? A protection order
She filed a petition for a temporary protective order.
on December?
It might have been end of November.
Tell me a date, ma'am. You just said something.
It's already been admitted as State's Exhibit 1, I believe. You reviewed that
She
document.
filed for a protection order in November of 2021. That's what you're asking me?
Yes.
Yes, she did file for a protection order in 2021 after she got mad at me about a
Sir?
TikTok video.
Okay, you've answered my question.
Oh, okay, go ahead.
Thank you. Okay, so were you present for the Zoom hearing on December 15th regarding that protective order?
Yes,
Okay, and you recall that the court actually issued a family violence 12-month protective order?
I recall that the court violated my Sixth Amendment rights by not letting me testify and bring in evidence.
Judge, I'm going to ask that his answer be stricken as non-responsive.
All right, Mr. Nicholson, if you'll answer the question, and I'm gonna ask the
What
jury
was
to
the question again, ma'am?
disregard.
This is Peg Leg's channel.
Disregard his last statement.
Do you recall that a family violence 12-month protective
Yes, ma'am.
order was entered?
Yes, ma'am.
And do you admit to violating that protective order?
No, I don't mean to violate the order because the person contacted me. I didn't violate the order because the order said that I violated, whatever, y'all said I aggravated stalking. I didn't commit no aggravated stalking. Aggravated stalking, I had to put the person, no, I didn't violate that
Judge,
by that.
again, I'm going to
I
ask
contacted the
that his
person.
response be stricken as non-responsive to the question.
All right. All right, I'm gonna strike his response. Mr. Nicholson, I'm gonna give you another opportunity to answer
I'm
the question.
subbed.
So Ms. Jones, if you will state your question again.
Do you admit to violating that temporary protective order?
With aggravated stalking or with a violation of protection order?
I'll re-ask the question. Let
Go
me
ahead.
withdraw that. I'll re-ask it. Did you contact Ms. Waldberg after the issuance of that temporary protective order?
After she contacted me, yes.
That's all I have. Thank you.
I rest my
Yes, ma'am.
case, Judge.
All right, Mr. Nicholson, is there anything else you wish to tell the court as it relates to what you were asked on cross-examination? It's what we call redirect, but you're not being questioned on direct.
Basically that she asked me questions. I never contacted Ms. Wahlberg. I mean, she contacted me and I contacted her. I mean,
Okay.
I responded and that's all.
All
In this
right.
whole situation.
I don't make
Thank
small
you. You
mistakes.
can step down. Mr. Nicholson, do you have any other witnesses?
YouTube
sir?
does that.
Yes.
Takes subscribers away.
No.
Okay. All right. So,
Yes. Oh, I forgot. The detective, I'm gonna call her back to stand.
okay.
So give her-
Beneke.
All right, Detective Aiken.
I love that for you, though. I love that you got sleep. Once you become a mod of so many channels, you can't possibly do it all. You can't. And then live a life.
All right, if you'll state your name again for the record, just
Detective Aiken.
Your first name.
Detective, oh, Jamaica Aiken.
All right, Mr. Nicholson.
They can, sir. Oh, shoot, my bad. Ma'am, I need you to verify, since you was the officer and you you're the detective and had possession and familiarity of this information. So I need you to verify that this evidence is for real.
Judge objection, there's no question.
right.
That was the greatest ever. I need you to verify. I need you to verify this information. That this information is I need you to verify that it's for real.
Mr. Nicholson, I'm going to need you to rephrase the question. I'm not certain that I understood.
No, that was
1 minute,
awesome.
Judge. Are you aware of the body cam video of the police officers?
All police officers wear body-worn cameras.
It was 2 police officers.
I did not view the body-worn cameras if you're asking me in reference to this case.
You never viewed the body cam camera?
No, sir.
If you repeat everything back to her a couple times, then you will win.
So you telling me you the lead detective in this case?
I am.
And you never looked at the information in this case, period? You just went off the instant and you wanted to hurt Mr. Nicholson?
No, sir.
Objection, compound question.
All right, Mr. Nicholson, one question at a time.
Yes,
So
ma'am. Oh.
break the questions up. Okay.
You stating that you never, as the lead investigator, looked at any information through the case.
That's not what I said.
Oh, so you just didn't look at the videos?
I didn't look at the BWC video. No, sir.
That's just hard to believe that you're a detective and this information was there.
Objection, argument it is.
All right, Mr. Nicholson, that's an argument. You can't make argument at this time. So do you have another question?
Judge, can you have the jury removed?
You have a legal matter?
Yes.
Okay. All right, ladies and gentlemen, at this time, I'm going to ask that you recess to the jury deliberation room. No conversing about the case, no research. If you overhear something, let us know as soon as possible. Thank you.
I'm gonna bump it forward 30,
Oh, okay.
back 10.
I have a discussion with you without her because I don't need her here.
Well, did I lose Ms. Jones? Oh, okay. So what is it that or are you asking me to, Mr. Nicholson?
The officer needs to leave the courtroom for me to be able to,
Okay, Ms. Jones? Well,
Right.
officer, just step outside for just a moment, please, if you don't mind, and we'll just go from there. Let the record reflect Detective Akins is gonna exit the courtroom for this line of conversation.
when I'm in front of a live audience, like,
Hold on. Hold on.
I hate being in front of a live audience too. It's not fun sometimes.
All right. So the detective has left the courtroom. And what is it that you'd like to tell me, Mr.
the
Nicholson?
detective overheard me, talking about this video, and I know she had to see this video, ma'am. She's the lead detective in the video. It's impossible for you not to review the evidence. And I know she heard me sitting back there talking, because she's been talking about she heard us all day. And I was explaining about the video and how.
All right. So, Mr. Nicholson, what is it that you're asking me to do?
Just because you don't like an answer does not mean that you can change the answer.
I'm attempting to try to play this video to for her to authenticate it, because she was the lead detective, and I mean the video shows.
Well, if you want her to review the video now to see outside the presence of the jury, I can have her do that.
Hi, Betty.
Yes.
Okay, Ms. Jones?
I don't understand what that's going to accomplish, because
Well, I don't know. At this point, I don't know if she was there when the video was taken. She doesn't have to be the one who took the video to authenticate it.
yes, it's
So-
my understanding she was not there, Judge.
Well, that I don't know, because, I mean, you're telling me that, but he has the right to ask her if she was there. So I'm not going to stop him from seeking to lay a foundation, but I don't want to do it in front of the jury at this point.
We had the officer brought back in, or the detective brought back in.
Now, she was not there, so that's not the basis that I'm trying to go off.
Okay, so what are you trying to do? In terms of what are you asking me to do?
She's the lead detective. She know the case.
Okay.
And she should be able to authenticate the video that I'm trying to introduce.
Okay,
Judge, I'm
Well-
going to object again, because this could have been covered when either the detective was on the stand, Officer Florio was on the stand, or Brianna Wahlberg was on the stand. He is not calling her for rebuttal purposes here. He is calling her seeking to basically introduce evidence that he could have gotten in when any of these other people were on the stand. This is a dilatory tactic. It's a waste of time, and this is one of the dangers of proceeding pro se, as the court has repeatedly explained to Mr. Nicholson.
Something about Rule 11, that, me as defendant, I'm entitled to call any witness that has been properly noticed to the state.
well,
To-
so I'm going to allow him to call the detective. My question to you, Mr. Nicholson, is do you want me to have her view the video now?
Yes,
And you can question her outside the presence of the jury
okay.
in your effort to lay a foundation to
Yes.
get this video in?
Yes.
Okay, let's have the detective. Anything else, Ms. Jones? All right, and so to the extent the state was objecting to him being able to call the detective, that is overruled.
But no, Judge, I would like to clarify the record. She's already been called.
Okay, so you're objecting to what then about
I'm
her?
objecting to this line of question.
Okay, I'm overruling that as well. Thank you.
This is Lebanon bologna. And I just found out recently that it's only here. Lebanon is right down the road from me, but it's just in Pennsylvania. Have you guys ever had Lebanon bologna? It's sort of like sweet bologna, but it's not.
All right. So let the record reflect Detective Akins is back in the courtroom and is on the stand, and this portion of the proceedings will continue outside the presence of the jury. All right, Mr. Nicholson, do you have the video queued up?
Yes, I have, the video queued, and we can play it.
Okay.
Just in my capacity as stand by counsel, to protect the record, I am turning on the screen and I'm playing the portion Mr. Nicholson has passed.
Okay.
The detective review, which is minutes 1 minute and 7 seconds to 7 minutes and 16 seconds. I believe that this video is Defendant's Exhibit 13. It's not yet been but
Maybe.
It would be 14.
It's
correct,
like German
Madam Clerk?
bologna.
Defendant's Exhibit. Are we up to 14? Okay, Defendant's Exhibit 14. All right. Detective, is that screen on? Okay, thank you.
Officer Florio, what's going on?
I just want to ask a question about PTO. So I have a PTO out on my son's father.
Okay.
He has abused me, has raped me. I got the officer, I think she's a detective out there on Tybee or something. She dumped my phone where the messages came from where he's done me. So we got a PTO a couple of weeks ago. Now today, he sends 2:00 this morning sending text to my stepdad. Son, a TikTok video, he has put my name, my children's name, my pictures, my business name, all over this website.
Okay.
And I'm just trying to figure out, and what he has done is he jumped town, he lives in Miami now. And that's why he's doing this. So what can I do? Because
Do you have the protective order on you?
I have it in the email.
Can I see it?
What's the guy's name?
Derek Nicholson,
Is that D-E-R-E-K?
Derrick.
And you said Wilson?
Nicholson.
Nicholson. And what's Derek's birthday?
It's June 8th, 1977. I got it from Space Shelter, but we got it December 15th.
Do you mind if I?
I'm sorry, we didn't post it.
No, you're okay.
I'm so exhausted with this man.
I understand.
All I want to do is leave a relationship. I let the rape and all that go. And he still want to bother me.
CRD, we love you too so much.
That's just probably somebody trying to figure out what's going on. But DJ, later. Later.
Probably. I don't know, but probably. There's not many foods I don't like.
Your Honor, just for the record, Mr. Nicholson has instructed standby counsel to pause the video as he believes the portion that he determines to be relevant is actually smaller than what was originally stated to the court and appears to be from that 1 minute and 7 second mark. Mr. Nicholson,
I'm so exhausted with this man.
Do you mind if I?
I got it from 8th, 1977.
And you said Wilson,
Nicholson.
Nicholson. And what's that, Derek?
So what came all over this website?
Okay.
And I'm just trying to figure out, and what he has done is he jumped town, he lives in my.
I can't hear either, guys.
Your Honor, it's my understanding that Nicholson, he has moved the browser back, and so it appears that he only wants, from minute marker 1 minute and 7 seconds to minute marker 1 minute and 49 seconds, which is a portion of Officer Flavio, FLAVIO's body worn camera footage contained.
Fabio.
Let me
Fabio's
find out
in
from
this
the state.
show?
Is the state still
Ooh.
objecting to this portion of the video being published to the jury?
I don't object to it being published to the jury if you can lay the proper foundation and authenticate the jury.
Okay. Mr. Nicholson? Detective Aiken is back on the stand. You have any further questions of her as it relates to the authentication of this video?
You lead, detective, you already testified, correct?
Yes,
You had access to all the files in my case, correct?
yes,
You turned the case file over to the DA's office, correct?
yes,
You are aware, Officer, Fleischer interviewed Ms. Wahlberg, right? Correct? You are aware that he interviewed Ms. Wahlberg?
I'm aware he made a police report.
He interviewed. The video, this video is in the police file, right?
It's on it's on evidence.com.
Ma'am, for the record, I mean, the detective had to see the video. It's impossible.
All right, so Detective, everyone doesn't know what evidence.com is. Is that part of the police file? Would that be considered part of the police file?
Yes, it's a connected to a body worn camera. So the body worn camera, all videos that's recorded is uploaded to that.
It's hard to believe that you didn't see this information.
Judge,
man. And just
I
feel
don't like
this
her
officer
answer,
is trying
so
to-
Okay,
make
you have to
her
ask
say
the
the right thing.
question, and then you can make any argument to me as it
So it's a
relates to
sworn
foundation.
statement that you the lead detective and you never saw this evidence.
I did not review the body worn camera.
Judge,
That-
imagine that when she the lead detective and
That's his emotional support coke.
I mean, some kind of way she had to see this evidence. I'm trying to bring this evidence in to show that, show the person, you know what I'm saying, that.
All right. So, Mr. Nicholson, I guess, what are you offering this video for, this portion of the video?
To
What
show
would
the
you be trying to
credibility
show?
of the victim, to show that the victim was never in fear of me. Like, the person just was trying to hurt me for TikTok, because of TikTok purposes.
Okay.
I never did anything.
All right, thank you. Let me ask the detective, I don't know, do you know where this house is?
I do not.
Did you ever go to this house?
No, ma'am. I interviewed both of them via telephone.
Okay, all right. Okay. Anything else, Mr. Nicholson, about, before we have the jury come back, or I'll hear any further objection from the state?
The state does not have further objection, Judge. I would just reiterate what I've said.
Okay.
I would like to take up the issue of the criminal conviction.
Yeah, I was gonna take that up as well.
Judge, I mean, she's the one that turned in this evidence to the DA's office. Just because she don't want to verify that it's real doesn't mean that it's not.
Well, you wanna ask her that question? Because
Yes.
I don't know that to be true.
I already answered that question, ma'am. She said that she turned over the file to the DA's office.
Is that correct, Detective?
I personally do not turn over body worn cameras. Body worn cameras
You
is,
just testified that. you
Hold
turned
on,
over the
hold
file.
on.
body worn cameras are worn by officers. It's something that's automatically uploaded that gives the DA, they have access to it. Body worn camera is also access to the public if they request it. All officers are able to wear body worn cameras.
Well, let me ask this question, because I honestly don't know. So when the information is uploaded to evidence.com, is everything that's attached to one case given a unique number? So
It's
that
given
the-
a case, a CRN. Yes, ma'am.
And so this video would have had that same CRN so that the DA's office would know that it's connected to this particular
Yes,
matter?
ma'am. Yes, ma'am.
Okay, all right. And to your knowledge, I guess you as the lead detective, do you confirm that everything that's in there appears to be related? Or is it just if everyone uses that number, that information isn't accessible to the district attorney's office as it relates to this particular case or any other case?
I'm confused.
I guess so. Is there ever a situation where it's possible that evidence that's not related to a particular case can be uploaded with the CRN number for another case?
It can be accidental if an officer accidentally tags the wrong video with the CRN.
So does anyone go back to check, if you're the lead detective, do you do anything to confirm that everything attached to that CRN number, once you decide that this is a case that you're presenting to the DA's office for prosecution, does somebody go and do some type of quality control to make sure that everything that's attached to that CRN number for a case that's going to be prosecuted, it belongs with that case?
If need be, throughout this case, the report was sufficed enough because I had a temporary protective order. And then also the report stated that this was violated. Then I contacted him via telephone. So I went off basically the report that was written. I did not go back to review the body worn camera after speaking with him and he admitted, and also having a temporary protective order in place.
Okay, all right. Any other questions?
Yes, Judge.
Well, I've about heard enough. So over the state's objection, the state had this in its discovery and made this disclosure. If Mr. Nicholson wants to publish this video to the jury, I will allow him that portion only since that's all that's been reviewed. So that would be State Defendant's Exhibit, what is it, 14? All right. It'll be published to the jury over the state's objection. If you want to do anything else to preserve that for the record, you can. In the meantime, Ms. Jones, and is there anything else before we take up the?
No, if we could take this up briefly, Judge.
Okay, so Defendant's Exhibit 5, excuse me, State's Exhibit 5.
I need to revise that. briefly.
Co-counsels whisper to each other all the time.
Verify. It does appear that the clerk from Florida attached a couple pages at the end that are not relevant to Mr. Nicholson.
Right.
However, I think that this batch, which I've split up, is all one case.
Right, that's what it appears to me. And then these other 2 pages, which I tabbed because they have, it may have been co-defendants' names from what I can tell. But here, let me give you that back. And it sounds like you are,
I have split it up into these 3.
okay.
Okay, so I will show, I can borrow a stapler though, because otherwise I'm going to drop these. Excuse me.
All right, so is it your intent to substitute?
Yes, Judge.
Okay, so Madam Clerk, you can give her that Exhibit 5 in your hand back. And then Ms. Jones, if you will let Mr. Nicholson see what it is you seek to substitute now.
I've no idea what's going on right now.
This is an original certified. I have to take this, stack it apart.
So do you want these others to be separate exhibits?
We can do 5A, B, and C.
Okay.
Thank you. Thank you.
this one thing, right? That's stapled together?
That's why I was wondering if it goes against her record.
Oh, this is like this. Oh, yeah, I'm good, man.
All right, so that will be State's Exhibit
Oh, I'm sorry.
5, A, B, and C in lieu of the original Exhibit 5 that was previously tendered but not yet ruled on.
Thank you, Judge.
Thank you.
And I apologize to the court and Mr. Nicholson for the confusion.
No problem.
Yeah, we deserve an apology for a lot of things that are going on here. They're going to lose their shisa.
Okay, so at this time, anything else before the court has the jury return? Mr. Nicholson?
No, ma'am. The video, right?
Right, it's admissible, so I'm gonna allow you to play it.
Was still my turn?
Pardon?
It's still my turn? Oh, she's finished.
You recalled, yeah, do you have any
Is
other
it
questions
still
for
my
the
turn?
detective in front
No,
of the jury?
skip 2 turns for
Okay,
you.
so you just want to publish the video?
We call her, yeah, we just for the video purpose.
All right, do you have any redirect, Miss Jones of the detective?
No, Judge.
All right, well, I'm gonna leave her here so you can say you have no more questions once the jury comes out, okay?
Okay.
All right, so let's have the jurors come back out, please.
It certainly is. It's every lawyer's dream. But this is a jury, and you never know what a jury's going to do. Never. People are people.
All right, please be seated. Welcome back, members of the jury. And at this time, I have to ask you the questions. Have any of you had or overheard any discussions about this case? Any research about the case? Any texting, posting about the case? All right, so at this time, Mr. Nicholson, do you have any other questions of Detective Akins?
No, ma'am.
All right, does the state have any other questions of Detective Akins?
No, Judge.
All right, Detective, you may have a seat. Thank you. Mr. Nicholson, do you have any other witnesses or evidence to present?
Yes, I have a video I would like to show the jury.
Okay, all right, and is it queued up and ready to go? You may, thank you.
Tell them what it's about.
You can have a seat, thank you.
You can have a seat. She should have snapped. Sit down.
For the record, Your Honor, standby counsel is playing Defendant's 14, which is beginning at minute marker 1 minute 7 seconds.
What's going on?
I just want to ask a question about a PTO. So I have a PTO out on my son's father.
Okay.
He has abused me, has raped me. I got the officer, I think she's a detective out there on Tybee or something. She dumped my phone where the messages came from where he's done me. So we got a PTO a couple of weeks ago. Now today, he sends 2:00 this morning sending text to my stepdad. Son, a TikTok video, he has put my name, my children's name, my pictures, my business name, all over this website.
Okay.
And I'm just trying to figure out, and what he has done is he jumped town, he lives in my.
Your Honor, I am pausing the video at 1 minute and 49 seconds per request of Mr. Nicholson.
Okay, all right, thank you. At this time, Mr. Nicholson, do you have any other evidence or witnesses to present? Are you resting at this time?
Yes, I just want you to know that, yeah, I'm ready.
Okay. Anything else from the state?
Everything from the state.
All right. So ladies and gentlemen of the jury, the evidence portion of this hearing has now concluded. And in a brief,
And he submitted that. He's like, we just fought forever so that he could play that to the jury. Oh, man.
amount of time, I will provide you with the instructions on the law. There are just a couple of things that I have to do before that. So unfortunately, I have to ask you to retire to the jury deliberation room, hopefully for the last time before you get the case to begin your deliberation. So I continue to ask you for your patience and thank you for your patience. You may not discuss the case at this time until the case is given to you, and no research about the case or posting it or texting anyone about the case as well. Thank you.
Jury's deliberating now, right?
Requests, the court has included everything
Oh,
except
no. Listen, I'm not going over jury instructions. Nope, not doing it. I'm not. Nope. I'm going to play the verdict.
the voluntariness. Take it out, okay.
And I didn't
And
edit
there's no
this yet,
obstruction
so
from the
now I
state,
have
correct?
to find
Okay,
the
sorry about
verdict.
that.
And
been back
it's
and forth.
short and it's hard to find.
Okay, thank you.
After they stand,
Recess. If anyone else needs to take one, go ahead, but no more than 5 minutes. Thank you.
okay, they're going on break.
And I were discussing this, so I want to make sure he's aware. My understanding is in a non-capital offense that he
Nope,
would have.
this is just stuff. We want the verdict. We just want the verdict now. It's over.
Jurors entering.
I will post closing arguments on my Patreon. I'll find them, I'll cut them, I'll post them.
Thank you. Please be seated. All right, members of the jury, welcome back. Before we begin with closing arguments, I need to ask you,
I
have
will
any of you
promise
had any communication or overheard
to put the well, let's just see if it's real short.
any discussions about this case?
Emailing them.
You, Mr. Nicholson.
I'm skipping the lawyers.
First off, I want to apologize for having me out here so long. I'm not a lawyer, but it's my life, and I live this situation. Even though the victim in this case didn't have no contact order on her, it didn't stop her from contacting me. It is relevant that she did make contact with me because it demonstrated she was not in fear for her safety. Through the situation,
I don't think
the person
so.
was a narcissist that wanted to hurt me.
I don't think it's going to be
And
long.
because I didn't let her get away, she made problems with me. For a person to say that she was attacked multiple times through a 2-year period, when this lady left every time I went through financial problems, or every time she just wanted to get mad or wanted to go cheat on me, and she came back as she pleased. No one never made her talk to me. I think in the evidence you would see messages where she say, "Oh, I took you off a block just to see what you was talking about." This lady was taunting me through this whole situation. She knew all I wanted was my child, and she knew I didn't want her anymore. I didn't want no trouble from this lady, so I left Savannah. I left everything. I was homeless. Didn't want to go back home because I didn't want my mom and them to. Anyway, I ain't hurt that lady, and I ain't mean no violence to that lady. I just asked about my child. Conversations went to different points where this lady said things, and I responded. If anybody got an iPhone, I'm not an iPhone user because I ain't got that kind of money. But with that being said, anybody that's an iPhone user know that you have these apps to delete these messages. This detective know. If she downloaded these evidence, she should have seen that this lady was messaging me through this whole situation, and she should have handled it differently. I talked to this detective. I tried to, you know what I'm saying, tell the detective that, ma'am, I wasn't, all I asked the lady to put me on child support. I just want to know if that's my child, which I felt it was. I took care of that child 7 months in my, I'm finished. Father's discharge. Discharge calls for, discharge has caused emotional distress by placing such person in responsible fear and reasonable fear, such safety or members of her and her family, by establishing a pattern of harassing, intimidating behavior in which serve no legitimate purpose. My sole legitimate purpose was for my son. I ain't want to deal with that lady no more. She used me, she abused me, she cheated on me, and I did nothing to this lady. Never been, if a woman would sit and call the police because of a TikTok video, or a man emailing them about their child, why she didn't call the police when she got beat up all those times that she said she did? In the evidence, before this protection order, this lady never said nothing about me beating on her. She left my house October 26th. In the message after October 26th, she stated that she never said I was abusing her, beating her. She said that. She never said I did that. But then you turn around the day after lawsuits have been filed of this detective trying to hurt me. And now you come in and now your story is you've been getting beat up for all these years. I never hit nobody, man. I never hit that woman.
Taser,
Period.
taser,
She hit me
taser.
multiple times on different occasions. I just sat there and let it happen. Why? Because I cheated on somebody else and I left her for that girl. I'm done. I ain't got nothing to say. Arrested her.
All right, thank you, Mr. Nicholson. Ms. Jones.
Nope, now it's verdict time. Now it's verdict time. So they're going to stand for the jury to leave. Okay, the jury's gone. Is the jury back? She'll unmute it. Don't worry. Don't worry. She will unmute it. All right. Nope, she's leaving. She's leaving. All right, guys. Woo, here we go. Here we go. Yes, security. I am taunting you. Get your laser, baby. Taser, not laser. Taser. Lasers are for kitty cats.
Mr. Foreperson?
Oh, they
It's
did
my
something.
understanding that, have you all reached a verdict? Is it unanimous? And has the verdict form been signed by you? All right, if you will hand the verdict to the deputy.
Type in chat, 1 for guilty, 2 for not. We got Kelly with a 1. We got Jay with a 1. We got Sue with a 1. We got Monica with a 1. Come on, Donald. I know you're going to put a 2 in there. Linus 1. CJ 1. Security 1. Ain't Peg leg 69. Donald 2. Peg leg 420.
Madam Clerk, let me see. Let me make sure it's. All right, I'll ask the clerk to publish the verdict. The defendant stand. Thank you.
In the Superior Court of the Eastern Judicial Circuit, State of Georgia, In the case of State of Georgia versus Derek Lamont Nicholson, case number SPCR 22-01960J3, in this verdict form, count 1 aggravated stalking, we the jury find the defendant guilty. So we all say the 13th day of September 2024. Signed, the jury foreperson.
All right, thank you. All right, do the
guilty?
parties wish for the jury to be polled? Mr. Nicholson? All right, Madam Clerk, if you will poll the jury, please.
No, Madam Clerk, we're not doing that.
Juror number 4, is your verdict now? Was this your verdict then?
Address that momentarily. If I could,
Thank you.
anything from Mr. Nicholson? All right.
I couldn't hear him.
I'm sorry, can you speak into the microphone?
Hi, ma'am, I'm just thankful, and I just asked, would I be able to have a day or two to get my affairs in order before the sentencing?
All right, I will address that momentarily. If I could, I'm going to go ahead and release the jurors, if you all will stand by. If the alternates, let them come around so that I can address them. I'll meet the jurors in the back. I want to thank you on behalf of all of the parties and the rest of my colleagues for your service. You will be excused, and you are now free to talk about the case to anyone that you like. Thank you. I'll meet you in the back too.
We hear about the sentence in a second, but no. They rarely sentence right away in a jury trial.
I do have my convictions that have already been tendered in.
Let me ask. All right, thank you. You can be seated. Does the state wish to be heard on the issue of remand pending sentencing?
We would ask that sentencing be held today, Judge.
Okay.
And if not, then we would ask for remand. Yes.
All right. Well, let me ask, is there any evidence in aggravation?
We have the convictions, Mr. Nicholson's prior convictions that have already been tendered into evidence. At this time, we would ask that States Exhibit 5A and 5C be considered by the court for sentencing purposes.
All right. Is it the state's contention that he qualifies as a recidivist?
Yes, Judge, under subsection A of OCGA 1710-7 and subsections.
I forgot about that recidivist. So he already has, what was it, 4 or 5? It's important. What was it? Did he have 4 or 5 prior convictions? Felony convictions, because that makes a difference. 7? Was it 7? 5. So yeah, 5. He said 5. Oh man. So that means he's in trouble. Like he's in a lot of trouble. He's gone away for a long time.
All right. I am not inclined to sentence today. I want to take a look at those convictions as well as the recidivism portion. So do you wish to be heard on the issue of remand?
Yes, Judge. In that instance, we would ask that Mr. Nicholson be taken into custody pending sentencing.
All right, Mr. Nicholson, you've asked for an opportunity to get your affairs in order.
Yes, ma'am. I got to get my dog situated. I got just want to say goodbye to my family, my other kids, and get my I got some money situations I got to get straightened out.
My concern, Mr. Nicholson, is that you reside out of state. So at this time, I am going to remand you into the custody of the sheriff's office. I will set sentencing at another date. You'll get notice of the sentencing hearing.
Judge, I mean, I never ran. I came here every time.
No, I understand, Mr. Nicholson, but it's a different circumstance now. The presumption of innocence is no longer with you. So you can go with the deputies. I'll set sentencing at a later date.
We can't do it today?
No, I'm going to set sentencing for another date.
That's it, guys. That's it. Do not get out of jail. Do not pass go. Do not pay $200. But he lives in another state, but he's homeless, but he has a full-time job that he works 18 hours a day. I don't even know what's going on with this man, but he is in the custody in Chatham, Georgia right now by Judge Tammy Stokes. I love her. And he's not homeless anymore, so it's a happy ending. Yes. Well, we didn't have time for Judge Fleischer today, but that's okay. That's okay. We always have tomorrow. No more TikTok for you. Are you allowed? I know they give you iPads in jail. Are you allowed to do TikTok? What are you allowed to do on your iPads? I know that you get iPads. I know that you do. My niece went to jail and she got an iPad. What are you allowed to do on the iPad? Has anybody, Lisa, you've been to jail, right? Oh, email your lawyer. Grand Theft Auto, legal stuff, research and calls. No, no, Fleischer, this stream is over 3 hours long already. Yeah, he's been to jail, right? Games and TikToks. Got 3 hots and a cot. Online courses. Guys, thank you so much for ooh, Linus. I'm not marrying you anymore now that you showed me there was something like this on the interweb. Tinder. I remember a guy that I used to know was at the local prison that we had, and I was dating him. Hold on, hold on, hold on, hold on. And he used to ask me all the time to email him stuff because he couldn't get to the website to look at something. He needed to know something, da da da. So he used to ask me to email stuff all the time. However, he was a prison guard. He wasn't in jail. He just wasn't allowed a phone. He was allowed what he had, his computer, and they weren't able to access. They were able to access the internet, but only certain sites. So, and email was one of them. So he used to have me email him stuff. He used to work 14-hour shifts. These prison guards, so they're scheduled, I think, for like a 9-hour shifts or something crazy. And then they automatically, like, without any preparation or anything, have to work a 14-hour shift. So you go into work thinking you're going to work a 9-hour shift, and then boom, you're working a 14-hour shift, and then boom, you have to be back in like 6 hours, and then boom, you're working a 14-hour shift. Um, it's crazy. They are outstandingly overworked. Long, long hours, short breaks in between, and he never knew when it was going to happen, and it just happened all the time. You just went to work every day expecting that you were going to have to work a 14-hour shift. And these are the guards protecting us from the criminals. So, yeah, I used to send him all kinds of stuff to make his night go a little better. There's easy wards and there's hard wards. Work release is the easiest ward to work in a prison because everybody's trying to be as good as possible so they don't get work release taken away. So when he was on work release, that was great. When he was in Gen Pop, it was bad. It was just bad. It was always something. So can we see all of you? What do you mean? Wrong button. It's look, I started this stream at 5 a.m. Nobody looks good at 5 a.m. That's why I hide down the bottom so that I'm very little. Mm. Oh, see, no, we don't have death row in our prison here. I mean, yeah, but are they? Are they really? Cap, I'm calling Cap on that. Just one more. You can fix this one. Just one more. Get that felon. My dating days are over. Felony or no felony? No. No. Thanks, Jay. All right, guys. I'm going to make sure I get some Fleischer in tomorrow and something else because I had this planned for tomorrow. Well, we just did it today. You guys have a great day and behave because it's Sunday and the judges aren't in today. So thank you, Lena. It's sparkly. I thought I would do sparkles. I would rather, nope, don't say that. That's that I can't say those words. No marriage. We'll just say no marriage. Security, anything you want, anytime you want. You just say it and I will do it. See you on Discord, guys. Behave today. Thank you. Outro. I never have my outro ready. My daughter saw my outro for the first time today and said it was just terrible. They're only supposed to be 10 seconds long. And I said, I was married 19 years. I had enough of 10 seconds.
Got these lights that ghost digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales waiting to the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes mirror sky so blue. In her jokes there's a truth so true. With extreme she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales waiting to the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm.